Yes, people. Yes, yes, yes. Hello. Hi, everybody. Hello, everybody. Hello, everybody. Hello, everybody. Hi, guys. Hi, guys. Hi, guys. Hello, everybody. How are you guys? Rahul Kanchan. Hi, Rahul Kanchan. How are you? Rahul Kanchan. How are you? Operation and mismanagement. Samarth S. Prasad, new student. How are you, Samarth? Where are you from? Hi, Veni. Good evening, guys. Good evening. How is your day going, guys? Yes, people. Yes, yes, yes. What were you guys doing before this marathon? Samarth S. Prasad. Samarth S. Prasad. Where are you from, Samarth? Guys, is my voice audible? Just send this link to as many groups as possible, people. From Mysore, sir. Samarth Prasad. That's lovely, bro. Lovely. Samarth, why were you not there in the last 3 marathon lectures? Guys, call everybody, call all your friends to join this marathon. We're going to have some amazing fun in this marathon. Yes, people. Yes, yes, yes. Call everybody. Call everybody. Send this link to as many people as possible. I will just share you the link, people. One sec, one sec, one sec. Samarth S. Prasad, Veni, what were you guys doing? How are you? How was your day? I was watching, sir, but didn't post comments watching from my friend's laptop. Okay. Samarth, so you are one of the guys who was not dropping comments, was just watching. Okay, Samarth. So now are you watching from your own laptop? Veni, fine, sir, fine. Okay, guys. Devika is back. Good evening, Devika. How are you? How was your day, Devika? How was your day going? What were you doing before this marathon? How is your preparation going on, guys? How is it going on? Guys, while watching this marathon, even after this marathon is ended, if you have got any doubts with respect to any topic in this marathon, immediately drop your doubts in the comment section. Within 24 hours, your doubts will be resolved, guys. Within 24 hours, your doubt will be resolved. Guys, if you have got any doubt while watching this marathon, after this marathon has ended, if you have got any doubts, immediately drop all your doubts in the comment section and your doubts will be resolved within 24 hours. Ganesh SP. Hi, Ganesh SP. How are you? Where are you from, Ganesh SP? Guys, we'll be starting in 5 minutes. All right. Let all the people come in. And then with full energy, let's continue with the Companies Act 2013. Today we are going to complete off with this Companies Act 2013. And by this end of this marathon, we're going to ensure that 60 marks is, you will have got 60 marks very easily. Fine, it was good, sir. Occupied with revision. Okay, Samarth. Good going, bro. Good going. Guys, it is very, very important to take care of your health in this very, very critical stage. There is just 1 month to go for your exams. So I would want you to please complete your studies. Apart from that, please take care of your health, guys. Sleep on time, eat well, do not eat junk food. And also take care of your emotional health, guys. Emotional health is very, very important, guys. Emotional health, there is nothing beyond taking care of your emotional health. You may study everything that's in the syllabus, but if you are not emotionally healthy, guys, then it's going to mess up in your exams. So do not engage into fights, do not engage into conflicts with any person in this 1 month. After exams, after you complete your exams, then you fight with everyone. But in this 1 month, do not let anyone hurt you, or you also do not hurt anybody, guys. Taking care of your emotional health is the best thing that you can do before your exams. What do you think about this, guys? Tell me. Chandrasekharan Gopal sir, good evening, sir. Good evening. How are you? How was your day going, sir? Within 2 minutes, we're going to start with this lecture, people. Within 2 minutes, we're going to start with this amazing marathon lecture. Yes, people. Yes. Is everybody there with me right now? Hi, Atul PS. How are you, Atul? How are you? Sakshi Jalan is back. Good evening, sir. Good evening, Sakshi. Good evening. How are you? Sakshi Jalan, you were not there yesterday and day before yesterday. Where were you, Sakshi? Okay, guys, it's 6:10 now. With full energy, with full excitement, with full power, with full focus, let's start day 4 of marathon batch for corporate and economic laws. Is everybody with me? Give me a quick, sweet, cute thumbs up, guys. Yes, people. Yes. Samarth, Ganesh, Devika, Chandrasekhar Gopal sir, Atul, Sakshi Jalan, Veni, Rahul Kanchan. Everybody give me a quick thumbs up. Today we're going to complete off with the Companies Act 2013. By the end of this marathon, 60 marks will be assured to you. We are done with SEBI regulations, we are done with Competition Act, we are done with FEMA. Today we will be done with Companies Act 2013, guys. 2013. I hope everybody got my notes, guys. If you did not get the notes, please drop me in the comment section that you did not get the notes, and notes will be given back to you immediately. With immediate effect, notes will be given to you. All right. So people, let's begin our first chapter for today's video, that is Inspection, Inquiry and Investigation. One of the most beautiful chapters, provided you understand the importance of this chapter, people. All right. Guys, tell me one thing. Have you heard about this Rose Valley scam? Are you aware of this Rose Valley scam? I will just give you a quick brief about this Rose Valley scam. Then only you will understand the importance of inspection, inquiry, investigation, that chapter that you find really, really dry and boring, I'm going to ensure that you're going to find this chapter super, super interesting when you know the importance of this chapter. All right, all right, all right, all right. People, this is my study material. So before I start any chapter, I always tell you one small story. That story which is super, so practical, that happened in real life, which is completely connected with this chapter. Then learning this chapter will be super, super exciting to you because you know the importance of the chapter. Where is it exactly applied? If you know this, that is no better thing to begin with this chapter. Yes, people. Yes, yes, yes. So, people, Rose Valley scam, the scam that happened in which year? Which year? It happened around 2013. People, Rose Valley. What did these guys did was they opened a company. What they did was they took investments from all the small category of people, marginal people, laborers, senior citizens who do not have any power. So please leave this revision videos till exam, sir. It will be useful. Of course, Ganesh SP, this video will be there on YouTube. Okay. All right. So Rose Valley people, Rose Valley scam, what happened was group of people opened a company where they promised investors that they are going to get double returns within a very few period of time. So what exactly happened was, I will tell you. In 2015, they took investments promising that they will receive 2x returns. Now, how are they going to provide 2x returns? No idea. Now, in 2016, they again received investment from people giving the same promise. Now, what happened was, using this money, they repaid these people. And in 2017, again, they took money from people. And then with this money, they paid this 2016 people. And in 2018, they again raised money. With 2018 money, they repaid to 2017. Like this, it kept on going. And the total fraud that happened in the company was, people, $17 billion was the scam that happened with the Rose Valley scam. After that, inquiry happened, investigation happened, and inspection happened. First inspection happened, then inquiry happened, then investigation happened. So everything that we are learning was clearly executed in this Rose Valley scam by the police officers. All right. So people, this is the importance of the chapter that we are learning right now. All right. Perfect. Is everybody with me? Let's begin the first chapter of today's marathon video. Is everybody with me? Give me a quick thumbs up. Give me a quick thumbs up. Yes, people. The first topic that we're going to understand is powers of inspector. What are the powers of inspector? Now that Rose Valley scam happened, no? So first thing will be done by the inspector. What we're going to understand. So people, what are the powers of inspector? That is section 217. So every officer, every employee and agents must preserve and produce records of the company plus all the related entities. Records must be produced. When inspectors ask the company, they have to produce all the records of not only their company but also their related entities. Number one. Number two, for how long can inspectors keep the record of the Rose Valley scheme? They have to keep the records for maximum 180 days, but they can also get extension. Number two. Number three, inspectors will have all the powers that a civil court has. Now, what are the powers that civil court has? Civil court has the power to ask for the discovery of documents. Number two, they can summon people and examine them under oath. And number four, they have inspectors. They also have the power to inspect records. Number three, they can also ask government, police and other authorities to help the investors. And number four, central government can make agreements with the countries, other international countries, to help with the investigation. Now we all know about the scam, that fraud that happened by Vijay Mallya. So just because central government had the agreement with UK government, they were able to call Vijay Mallya into the company, into the India. Then only they were able to imprison him. Understood, guys? Yes. So what are the powers of inspector? Every officer, every employee, whether formal or present, or any agents, must preserve and produce records of not only their company but also related entities. Number two, they can keep the records for maximum how many days? For maximum 180 days. Number three, inspectors will have all the powers of a civil court. What are the powers of civil court? They can ask for the discovery of the documents. Number two, they can summon people and examine them under oath. Number four, they can also inspect all the records that the company has. Number four, inspectors can take help of whom? Central government, state government, police and other authorities. Number five, central government can make agreements with foreign countries to help them with the investigation. So these are the powers of inspector. Is everybody with me? Give me a quick thumbs up. Give me a quick thumbs up, guys. Yes, people. Yes. Give me a quick thumbs up. Ganesh SP, Samarth, Rahul Kanchan, Chandrasekhar Gopal sir, Sakshi Jalan, Veni, Atul PS. Yes, Rahul. Yes. Perfect. Now, let's understand. How is the investigation done by a serious fraud investigation officer? Now, first we understand who is going to set up serious fraud investigation officer. Central government basically sets up serious fraud investigation for what? To investigate company frauds. Okay. Next. Now, when will a serious fraud investigation officer investigate into the matter of company, like let's say Rose Valley? If they receive a report from central government or inspector saying that something fishy is going on in the company, and number two, company itself is saying that fraud has happened in the company, something is wrong happened in the company, we want to know who exactly did this fraud. So company can, by special resolution themselves, can refer this matter to serious fraud investigation officer. Number three, if in the public interest, central government believes that it is required to investigate into the matters of the company, allowed. Request by a central government or state government department. All right. So when does serious fraud investigation officer investigate into the matters of the company? In four scenarios. Quickly tell me, well, what are the four scenarios? Give me an answer in one word. Number one is report from registrar or inspector. Number two, special resolution by the company. Number three, if it is in the public interest, that company has to be investigated. And number four, on request by central government or state government department. All right. Next, exclusive investigation. So once SFIO has been assigned, no other agency can investigate on the same matter. SFIO is always on the top. Once a case has been assigned to SFIO, no other investigating authority can inquire into the affairs of the company. Before SFIO have come in, all the previous investigating agencies have to submit all the documents, all the reports, all the information that they have gathered to whom? SFIO. Next, investigating officer who appoints, basically SFIO, director of SFIO appoints officers with inspector powers. Basically, people, do you know who is ACB Pradyuman? If you guys know who is ACB Pradyuman, give me a quick thumbs up. So basically, central government will appoint a CID and CID will appoint who is going to investigate the matter, whether it is Abhijit, whether it is Daya, whether it is ACB Pradyuman. So from SFIO will appoint one investigating officer with inspector powers. We know what are the powers of inspector. All right. Next. Now, SFIO is so powerful that company, employee and other officers, whether current or former, have to assist and provide all the documents and all the information that SFIO asks. Number 6, SFIO can provide interim report or final report to the central government. And number 7, any concerned person can get access to the documents prepared by SFIO by going to the court, by getting a special court approval. And number 8 is based on the SFIO report, the central government will order prosecution. Central government will take the person to the court. Person will include employees, officers and others involved based on the SFIO report. Is everybody with me? Give me a quick thumbs up. 1, 2, 3. 3 topics remaining to complete with the first chapter. These chapters are super small, people. Just give me a quick, sweet thumbs up so that we can quickly begin with the next topic. Are you guys with me? Rahul Kanchan, Sakshi Janan, Atul PS, Chandrasekhar Gopal sir. Where is Veni? Where is Samarth? Ganesh SP? Veni is there. Perfect, guys. Perfect. Amazing. So let's continue with the next topic. That is powers of the registrar. No, not powers of registrar. It is search and seizure. Okay. Now, what is the meaning of search and seizure? Search means what? Official examination of records of the company or premises of the company. Official examination of records or premises of the company is called as search. What is meant by seizure? Seizure means forcibly taking of the property by the authority is called as seizure. Now, when will seizure happen? Seizure will happen when the registrar or inspector believe that the records are destroyed, records are altered, records are hidden. In that case, seizure can happen. Number 2. Now, these things are done by whom? It's done by company, KMPs, director or auditors or practicing company secretaries. If these things are done by these people, then seizure can happen. Number 3. Seizure cannot happen just because these people are doing that. Just because these people are destroying, altering, hiding documents, only for that reason, seizure cannot happen. Seizure can only happen when they will have whose approval first? Special court's approval is required to do such a serious matter, that is seizure. And last is they can after doing all these things, they can enter, search, seize books and papers. Okay. So when does seizure happen, guys? Tell me quickly. Quickly answer me the question. When does seizure happens? Number 1, when records are destroyed, altered or hidden by whom? Company, KMP, directors, auditors or PCS. Now only for that reason can seizure happen? No. Seizure can only happen when you get special court's approval. And after that, they can enter, search and seize the premises, books or papers. Is everybody with me? Give me a quick thumbs up. Now, for how long, when the documents have been seized, how long can the inspector or SFIO keep with them? They can maximum keep it for 180 days, which can be extended upon written order. Easy. Now, people, now that we are learning when does seize happens, okay, we are basically understanding a brief procedure about seizure. Now, detailed procedure about how does seizure happens is written in a Criminal Procedural Code 1973. Every single thing, when will the police officer come, how should the police officer handle the people, the complete procedure is being listed in the Criminal Procedural Code. They have SFIO and inspectors have to follow that code. when they do the seizure. Is everybody with me? Quickly give me a quick thumbs up. Is everybody with me? If I'm going too fast, please tell me in the comment section that, sir, you are going too fast. Please reduce your speed. All right. Perfect, Rahul. Perfect. Amazing, guys. Amazing. Yes. Now that we have understood the powers of inspector, now that we have understood how will SFIO investigate the matter, and number 3, now that we have understood search and seizure, now we're going to understand what are the powers of registrar. Okay, so registrar can send notice to the company asking for information, explanation, or documents. Registrar can send notice to the, what are the powers of registrar? Registrar can send notice to the company asking for documents, asking for information, asking for explanations. Number 2, company officers, employees, whether former or current, have to comply, have to submit all the information within the reasonable time. Now, additional notice, if no or inadequate response or improper response have been submitted, or if the inspector registrar finds that the company's affairs are conducted in a improper manner, in that case, registrar can demand additional information. And last is, reasons for asking for the additional information must be given in writing. Hi, Siddesh Reddy. All right. Now, inquiry by the registrar. Now we understood how will the registrar seek for information. We understood how will the registrar ask for additional information. Now we're going to understand when will an inquiry be ordered by a registrar. If fraud, unlawful activities, or investor grievances are suspected, registrar can start an inquiry. So, if fraud, unlawful act, or investor grievances have been suspected, registrar can start an inquiry. Number 2, company must be informed and given a chance to respond. It should not be a case where just because registrar thinks the company is doing fraud, registrar can immediately start an inquiry. Company should get the opportunity of being heard first. Company should be given the opportunity of being heard. And number 3, central government can appoint a registrar or inspector for this company. And last is, every officer in default may face charges as per section 447 that deals with fraud. Is everybody with me? Give me a quick thumbs up. Give me a quick thumbs up. All right. Now, inspection by central government. Central government can also order inspection by inspector or stat authority. Number 2, non-compliance can lead to penalties. Very easy. Next, what are the duties during inspection? Number 1, directors, officer, employees must produce documents, give statements, information, explanation, and last is they have to fully cooperate. Very easy. Next, what are the actions that are based on the inspector's report? Section 224, prosecution. If offences are found, the central government may prosecute. That means take them to the court. And whom? Guilty person will be taken to the court. Number 2, officers and employees must assist in the prosecution. Number 2, legal proceedings. If public interest demands, central government can also direct the company or body corporate to do 2 things. Number 1, recover damages for fraud or misconduct. And number 2, recover misapplied or wrongly held property. The central government can also initiate winding up if required. Central government can also tell the company that you have to now close down all your operations. The same way central government told to this Rose Valley scam. Rose Valley company, central government ordered them to close down the company. Now, cost recovery, company or body corporate must reimburse the central government for cost or expenses that were incurred during investigation. We are done with this chapter of inspection, inquiry and investigation. Is everybody with me? Are you guys ready for MCQ questions? Are you guys ready for MCQ questions, guys? Perfect. Now I'll tell you what type of questions will be asked in your exams. These are the expected questions that is going to be asked in your exam, people. Now, people not ever understood what are the powers of inspectors. Okay, you have to write 5 points. Now, in exam, so easily question will not be asked. What are the powers of inspectors for 7 marks? No. Such an easy question will never be asked in your exam. Question will be asked in exam in such a manner, I will tell you. Explain the powers of inspectors regarding preservation, production and retention of company records under section 217 of the Companies Act 2013. Or discuss the civil court-like powers granted to inspectors during investigation under section 217. Provide examples where applicable. Analyze the role of central and state governments and police authorities in assisting inspectors during company investigations. How does the Companies Act 2013 facilitate international cooperation for investigation under section 217? Discuss with relevant provisions. And last, critically examine the retention limit prescribed for records seized by inspectors and explain the process for extension. All these questions will only have one answer. That answer is this. Powers of inspectors. That's it. Question will be asked in exam, twisted and turned, but you should not get worried, people. Okay, always remember ask yourself what exactly is the question trying to ask me. When you get the answer, that answer will be so simple. Okay, is everybody with me? I've already told you on day 1 of marathon lecture that every time you give any answer, always try to write examples. Always try to write examples. All right. Now, is everybody with me? Give me a quick thumbs up. Give me a quick thumbs up for whoever is watching right now. Give me a quick thumbs up. People have given you all the expected questions that's going to be asked in the exam. Okay. Powers of inspector. Topic is, we know the topic. Content is also given. What I've done is, I've included what all type of questions twisted and turn will be asked in the exam, for which answer is going to be the same one. Investigation by SFIO. What are the circumstances under which SFIO is authorized to investigate a company under section 212? Explain with examples. All these questions will only have one answer. Investigation by SFIO. That's it, people. That's it. It's as simple as that. Do not ever get panic when you see such difficult twisted and turn questions. All right. Perfect. Now let's begin with the MCQ part. Yes. Tell me the answer of first question. What is the primary purpose of an inspection? Discovering fraud, ensure compliance with laws and regulations, punish wrongdoers, or seize property. I've told you inspection word. What is the answer of this? Is it answer A? Is it answer B? Is it answer C? Or is it answer D? What is the primary purpose of an inspection? What is the primary purpose of an inspection? Answer is A. Rahul Kanchan says answer is A. Okay, Rahul. Rahul Kanchan is saying answer is A. Sakshi Charan is saying answer is A. Guys, I've told you inspection, okay? There's a difference between inspection, inquiry and investigation. Yes, guys. Yes. Everybody quickly tell me the answer. What is the primary purpose of an inspection? Whether it is discovering fraud, whether it is to ensure compliance with laws and regulations. Number 3, punish wrongdoers. Or last is seize property. Vaini is saying answer is B. Okay, Vaini. Yes, yes, yes. Guys, everybody answer me. Everybody. Whether it is wrong or right, doesn't matter at all. Just answer. Atul PS is saying answer is B. Vaini is saying answer is B. Sakshi is saying answer is A. Rahul Kansan is saying answer is A. All right, all right. Chandrasekhar Gopal sir, what do you think? Samarth S. Prasad, what do you think, guys? Ganesh SP, tell me, what do you think? Answer is B. Yes, people, you are guys. First class, fantastic, guys. Vaini, Atul PS, Chandrasekhar Gopal sir. Amazing, guys, amazing. Rahul Kansan, Sakshi, always read the question very, very properly. Every single word is important. Next question. Which of the following usually arises due to complaints or suspicious activities? Inspection, inquiry and investigation, annual audit, or due diligence? Two B. Rahul Kansan is saying answer is 2B. Okay. Rahul Kansan is saying answer is 2B. Guys, everybody quickly answer me. Quickly. As quickly as possible answer me so that we can begin with the next chapter. We will try to complete today's marathon within time, people. 9 p.m. All right. I don't want you guys to sacrifice or, disturb your sleep schedule. Devika is, oh my God, Devika is back. Devika is saying answer is A. Vaini is saying answer is B. Okay, okay, okay. Answer is, Atul is saying answer is B. Answer is B. Perfect, guys, perfect. Amazing, amazing, amazing. Now, who has the power to call for information from a company under section 206, subsection 1? Whether central government, whether SFIO, whether ROC, or whether NCLT. Who has the power to call for information from a company under section 206, subsection 1? Guys, I hope you are not looking at the answer from the notes. Rahul Kansan is saying answer is B. Vaini is saying answer is B. Chandrasekhar Gopal sir is saying answer is B. Atul is saying answer is B. Perfect, guys. Perfect. Amazing, amazing, amazing. Last question, then we will move on to the next chapter, okay? If a company does not respond properly to the registrar's notice under section 206, subsection 1, what can the registrar issue? Whether arrest warrant, whether search warrant, whether additional written notice under section 206, subsection 3, or number 4, directly freeze order. Sakshi Jaran is saying answer is B. Perfect, Sakshi. Perfect. Amazing, guys. If a company does not respond properly to registrar's notice under section 206, subsection 1, what can the registrar issue? Arrest warrant, directly arrest warrant, or search warrant, or additional written notice, or last is freeze order. Hi Pooja Gupta, how are you? Answer is 4C. Answer is 4C. Atul is saying answer is 4C. Anybody else? Guys, 13 to 14 people are watching. I want you, everybody, to drop your answer, guys. 4C, 4C, 4C. All right, all right. Perfect, guys. Perfect, perfect, perfect. Amazing, amazing, amazing. With this, let's start our next chapter. Superb, Sakshay, superb. All right. So our inspection, inquiry, and investigation is completed. Now, next chapter we'll pick is prevention of operation and mismanagement. People, this chapter is very important chapter. Every single time questions are asked from this chapter. 1 or 2 questions are definitely asked from this chapter. Inspection, inquiry, investigation, max to max. 1 question can be asked or cannot be asked. But prevention of operation mismanagement, from this chapter, questions are asked. At least 1 or 2 questions are definitely asked in the exam. All right. Yes, people. Yes, yes, yes. Let's get started. Prevention of operation mismanagement. Yes, people. All right. People, question will be asked in this manner. XYZ Limited has 500 shareholders, but only 50 shareholders are actively involved in the decision-making process. A small group of these active shareholders have been making decisions that significantly harm the interest of these shareholders. Several minority shareholders want to challenge this operation but are unsure whether if they meet the legal requirements for filing an application with the tribunal. Now, what is the question asked? Under section 244, what are the eligibility criteria for these minority shareholders to apply to the NCLT for relief? What options do they have to proceed if they don't meet the requirements themselves? Now you have to answer this question. Okay, so now such type of question will be asked in exam. So our first topic is right to apply to tribunal. Section 244. Hi Samarth, thumbs up means what, Samarth? Anyways, thank you Samarth, thank you for the thumbs up. All right. Now, section 244. When can you apply to tribunal? When can you apply to tribunal? What are requirements you have to comply with before you apply to a tribunal to say operation and mismanagement? People, before we understand this in detail, I will give you a small example so that I can explain you properly. We all know who is Jeff Bezos. We all know who is Jeff Bezos. Right? Jeff Bezos was a minority shareholder in which company? Future Group. Jeff Bezos was a minority shareholder in the Future Group. Okay. So before Jeff Bezos had invested in the Future Group, he made clearly to the founder of Future Group saying that you cannot accept investment, you cannot deal with Reliance Industries if you require my investment, because Reliance Industries and Amazon are direct competitors. So you cannot deal or engage or accept investment from Reliance Industries. Based on this condition, Jeff Bezos had invested in the Future Group. But people, what happened was, the moment Future Group was going on debt, the moment Future Group was going into losses, immediately it made a deal with Reliance, where Future Group agreed to sell all its stores to whom? Reliance. Future Group agreed to sell all its stores with Reliance. Now, this is a case of operation against Jeff Bezos. Is everybody with me? Is everybody with me? Tell me one thing, can Future Group engage in such agreement with Reliance? Tell me, people. Do you think it is right for Future Group to engage with such agreement with Reliance despite of having an investment clause where he clearly agreed to Jeff Bezos that we will not engage or deal or accept investment from Reliance? Do you think what Future Group did was right? Jeff Bezos was a minority shareholder. That means this is a case of operation against Jeff Bezos. Is everybody with me? Give me a quick thumbs up. Give me a quick thumbs up. Now, based on this example, I'm going to teach you everything. Amazon went to Singapore Tribunal, Singapore Arbitration Tribunal. Singapore Arbitration Tribunal passed order in favor of Jeff Bezos, but still Future Group did not agree to that order, saying that Singapore Arbitration Tribunal is not acceptable in India. Then Jeff Bezos went to NCLT. NCLT also ordered in favor of Jeff Bezos. Still, Future Group did not agree to that. Then Jeff Bezos went to Supreme Court. And by the time Jeff Bezos went to Supreme Court, Future Group nearly sold all its store to Reliance, and the effect could not be reversed. In that case, Reliance had won against Jeff Bezos, despite Jeff Bezos being the right person in the story. Is everybody with me? Is everybody with me? Samarth Prasad, amazing Samarth, amazing. Pooja Gupta, Atul PS, Veni, Rahul, Kanchan, Sakshi Janan, Chandrasekhar Gopal sir. Is everybody with me? Devika, give me a quick thumbs up. Samad, you are from which place? Veni, excellent, Veni, excellent, amazing. Samarth Prasad, you are from which place, Samarth? Now is it interesting? Now is operation and mismanagement interesting now, people. This is how you should learn every single chapter. Perfect, 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 perfect. Now, let's understand, when can Jeff Bezos apply to tribunal? Basically, now I'm teaching you when can Jeff Bezos apply to tribunal. Section 244 allows certain members to apply to NCLT for relief in cases of operation and mismanagement under section 241. So, when will Jeff Bezos be, first of all, eligible to file a case for operation and mismanagement? For companies having share capital at least 100 members or 1/10 of total members, whichever is lower. Okay. Number 2, or any person who's holding 1/10 of the share capital can also go to the tribunal. So 2 people can go to in 2 situations. Operation and mismanagement case can be filed. Number 1 is either 100 members or 1/10 of the total members, whichever is lower, can file a case against operation and mismanagement with the tribunal. Number 2, or any other member who is holding 10% of paid share capital can also file case of operation and mismanagement. In this case, Jeff Bezos should have held 1/10 of the share capital in Future Group, then only he is eligible to file a case of operation and mismanagement against Future Group. Number 2, this is for share capital. For companies without share capital, 1/5 of the total member is sufficient. Now, NCLT can waive eligibility requirements. Means what? NCLT, even though you do not comply with the eligibility requirements, still if NCLT feels right that they should allow your case, they can allow your case. Next, filing on behalf of others. Eligible members can file on behalf of others with written consent. Now, this provision protects minority shareholders and ensures corporate governance. Is everybody with me? So now we understood eligibility, we understood how can tribunal waive off the requirements, and number 3, if can a person file on behalf of others for a case of operation and mismanagement. All right? Yes. Now, application by central government to tribunal for relief in cases of operation and mismanagement. Is it compulsory that every time members should file a case of operation mismanagement, central government can also file themselves case of operation and mismanagement. Now we will understand if central government really has the power to file a case of operation mismanagement. Section 241 allows central government or a company member to apply to the tribunal if company affairs are being conducted in a manner prejudicial to public interest against the interest of the company. Number one, central government, when can central government file a case of operation mismanagement? If central government thinks that the company's affairs are conducted in a manner that is prejudicial in the public interest, in that case central government can apply to the tribunal. Now, what should be the case, what should be the scenario for Jeff Bezos? Then only he can apply to the tribunal. Now we understood, first of all, is Jeff Bezos is eligible to file a case of operation mismanagement. Now we'll understand what exactly should have happened to Jeff Bezos for which he can apply to tribunal. A member can apply to tribunal when, if affairs of the company are prejudicial to the public interest, number one. Number two, oppressive to any member or a group. And number three, it is harmful to the company's interest. In that case, Jeff Bezos can file a case of operation and mismanagement. Material changes in management control means what? If changes in a board or membership manager proposition. Yesterday I told you how Cyrus Mistry was removed from the Tata Sons group without having his consent. Without the proper board approval, Cyrus Mistry was removed from the board of directors of Tata Sons. So that should not be allowed. Changes in the board or managerial position not allowed. Number two, any alteration in the ownership or membership structure. This thing that happened with Jeff Bezos, wrong. And third is any change that could affect the company's affairs in a negative manner. In that case, operation and mismanagement case can be filed. After doing all these things, then you have to check whether you are eligible, first of all, to file a case of operation mismanagement. Is everybody with me? Give me a quick thumbs up. Central government can also apply if it believes that, okay, this is done. All right. Perfect, perfect, perfect. Is everybody with me? Is everybody with me? Give me a quick thumbs up. Everybody there with me, give me a quick thumbs up. Yes, perfect, 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 perfect. Now we're going to understand what are the powers of the tribunal. Tribunal has broad powers, okay. Conditions when can a NCLT intervene themselves. Tribunal may intervene if it finds two things. Number one, company affairs are prejudicial to any member or public interest or company's interest. In that case, NCLT can intervene. Number three, over there, people, NCLT will check two things. Number one, if really operation mismanagement has happened against the public interest, against the members or against the company's interest, number one. And number two, if the NCLT is satisfied that winding up or closing up of the company would not be possible, because if we end up winding up or closing up the company, it will be a super great detrimental loss to all the members, to all the creditors, to all the stakeholders. In that case, if NCLT believes that company cannot be shut down, but some changes should happen in the company, in that case, NCLT can intervene in the matter. Now that NCLT has intervened, what all orders can be passed by National Company Law Tribunal, we are going to understand. First, he can regulate the future conduct of the company's affairs. He can regulate the future conduct of company affairs. He can give a strict warning that company should not conduct actions or conduct any affairs in a manner that is prejudicial to the company's interest. Number two, compelling members to purchase shares from the others of the company. Which means what? NCLT can ask Future Group to first purchase the shares of Jeff Bezos. You give him the exit opportunity and then you do whatever you want with the Reliance Group. NCLT can order that. Number two, after that, and after Future Group has acquired the shares of Jeff Bezos, NCLT can ask the Future Group now to reduce the share capital as you have bought back the shares of Jeff Bezos. And next is restricting share transfers or allotment to prevent unfair control shifts. NCLT can ask Future Group to not to sell any shares to Reliance Industries. Strict warning. And next is modify or set aside whatever agreement and Future Group has done with Reliance Group. NCLT can order to modify or setting aside, can cancel the agreement, whatever agreement they have entered with the Reliance. And next is ensuring third party agreements are not modified or terminated without proper consent. Who is the third party over here? Jeff Bezos was the third party over here. NCLT can give a strict order that whatever agreement you are doing with Reliance, ensure that Jeff Bezos is not harmed in any manner. Next, NCLT can reverse fraudulent transaction. Now, these are the main points that we are supposed to remember. These are very, very easy. Regulating the future conduct of the company's affairs, very easy. And last is also very easy. Issuing any other just or equitable orders is very easy. Now, these four points deal with the company's internal management. Restricting share transfers or allotment to prevent unfair control shifts. Next is, okay, people, we are studying this. All right. Yes. Removing KMP. Number one, NCLT can order to remove the KMP. Number two, NCLT can order to recover undue gains made by the KMP. Next is regulating future appointments of MD or managers after removal, which means what? If manager of MD is guilty of fraud, NCLT will order strictly to the company that after this, whenever you are going to appoint MD and manager, you have to follow XYZ conditions before you are going to appoint him. Next, appointing independent directors to report on company's affairs, which means what? Company is doing a lot of fraudulent activities, fishy activities. So NCLT will order the company to appoint an independent director so that company's affairs are conducted in a proper manner. And next is imposing cost or penalties as required or any other order that may be deemed fit. People, I will tell you one thing. First point, that is regulating the future conduct of the company's affairs, is easy. And last is issuing any other just and equitable orders is easy. Now, everything that is related to shares, 2 points are related to shares, red points are related to shares. Next, these are the 4 main orders and 4 orders that relates to internal management, and this is imposing necessary cost. Next, now that tribunal has ordered these things, this order must be filed with ROC within how many days? Within 30 days. Now, tribunal can also issue interim orders, okay, restrictions and alteration. Now, the company cannot alter its memorandum or articles in a way that is not consistent with the whose order? Tribunal's order. Company cannot now alter the memorandum of association or articles of association that is inconsistent with the NCLT order. NCLT has clearly told the company that you have to follow a specific procedure whenever you're going to appoint a MD or manager. Now the company cannot alter its memorandum and articles as per its whims and fancies that will say how should a manager be appointed. Is everybody with me? Give me a quick thumbs up. Give me a quick thumbs up, guys. Yes. After this, last topic is something, then we are done with the chapter of operation and mismanagement. Give me a quick thumbs up. Is everybody with me? Atul PS, Sakshi Sridharan, Veni, Devika, Rahul Kanchan, Gopal Sir, Samarth S. Prasad, Pooja Gupta. Guys, give me a quick thumbs up. Perfect, Vinny. Perfect, perfect, perfect. Sakshi Sridharan is there with me. Guys, am I too fast? Just tell me if I'm too fast. I will just reduce my pace. Okay? All right, all right, all right. Let's move on to the next concept, that is class action suit. Can anyone tell me the difference between a class action suit and right to apply to tribunal as per section 244? What is the basic difference between a class action suit and right to apply to tribunal? 244. Over here also we understood that a person can file a case on behalf of others. Then what makes the class action different from this provision? Answer means shortest way possible, guys. Can anyone tell me the basic difference between a class action suit and right to apply to tribunal on behalf of everybody? Guys, if you do not know the answer, just give me a thumbs up. If you know the answer, please tell me the answer. Can anyone tell me the basic difference between a class action suit and right to apply to tribunal on behalf of others? Swati Gupta. Hi Swati Gupta, how are you? Where are you from, Swati? Swati Gupta, my question is, what makes a class action suit different from right to apply to tribunal on behalf of everybody? Just now we understood when can a person apply to tribunal, either on himself or on behalf of others. Now what makes a class action different from this one? Yes, people. Yes, yes, yes. Anybody else? Give me a quick thumbs up. If you know the answer, give me a quick thumbs up. If you do not know the answer, if you know the answer, tell me the answer. If you do not know the answer, give me a quick thumbs up. All right. I will wait for 1 minute max. Hey Siri, timer for 1 minute. Protecting minority shareholders' interest. Chandrasekhar Gopal sir, yes, you are right, sir, but I want to know the basic difference between a class action suit and filing application on tribunal on behalf of everybody. Now that we have understood that application can be filed on behalf of everyone to the tribunal, then why are we studying class action suit? Is my question. What makes a class action suit different from section 245? Sorry, right to apply to tribunal. That is section 244. 244. Yes, people. Yes, yes, yes. All right, all right. No problem. I'm going to answer the question. People, section 245 and class section 245 section 244 class action suit application on behalf of everyone. So people, when illegal things, illegal conduct happen in illegal ways, illegal things happen in legal ways, sorry, and over here illegal things happen in illegal ways. This will deal with fraud. This will deal with the case of Jeff Bezos. You tell me, did Future Group made any did Future Group was Future Group engaged in any fraud? No. It just took decisions that were against the interest of the minority shareholders. For that reason, section 244 will be applicable. But in cases of fraud, in the cases of illegal activities going on in the company, in that case, class action suit will be filed by the members in the end who are getting affected. Understood, guys? Understood? Is everybody with me? Give me a quick thumbs up. Yes. Now we're going to understand what is the meaning of class action suit, people. Class action suit, who can file basically for companies with share capital, again, at least 100 member or a prescribed percentage. Companies without share capital, 1/5 of the total members. Very easy. Who can file? A person, group or association representing affecting members or depositors can file a class action suit. Now, what are the grounds for filing? Stopping ultra vires act. If the company is acting beyond its memorandum, articles or Companies Act 2023 to stop that ultra vires act. And number 2, preventing breaches, restrain violation of the company's rules and laws. And number 3, void resolution, nullifying resolution passed through misrepresentation, which means what? Based on wrong facts, based on misrepresentation, based on fraud, company has passed a resolution to make the resolution void. For that reason, class action suit can be filed. Number 2, stopping wrongful resolution, which means what? Prevent execution of such resolution. Which execution? This one. First of all, you should not pass this resolution at all. Number 2, you cannot execute that resolution in the first place. Next, restraining illegal activities, stopping illegal activities under Companies Act 2013. Next is enforce valid resolution, ensuring actions align with member resolution. And last is claiming damages, seek compensation for what? Fraudulent acts by the company directors or auditors. So, what are the grounds for filing class action suit? Number 1, stopping ultra vires act. Number 2, preventing breaches. Number 3, void resolution. Number 4, stopping wrongful resolution. Number 5, restraining illegal activities. Number 6, enforcing valid resolution. Number 7 is claiming damages. Now, what is the process? Process basically tribunal issues a public notice to inform affected parties. Number 1. Number 2, tribunal consolidates all the similar cases so that no duplicate cases are filed. Number 3, appointing a lead applicant if members do not agree. Last is all the legal costs should be borne by whom? Company and all its responsible officers. Next, the orders of tribunal are binding on whom? Binding on company, members, depositors, auditors, and all the related professionals. Penalties for non-compliance, 5 lakh to 25 lakhs fine, and officers will be jailed up to 3 years imprisonment and fine up to 25,000 to 1 lakh. This is exempted from banking companies. The rule that we have studied just now, class action suit, is exempt for banking companies. Can anyone tell me why this exemption has been made to banking companies? Can anyone tell me why class action suit cannot be filed against a banking company? Can anyone tell me why class action suit cannot be filed against a banking company? Yes, people. Yes, yes, yes. Can anyone tell me why exemption has been given to banking companies? People, class action suit cannot be filed against a banking company because the reason is RBI is there. Perfect, Rahul. Perfect, perfect, perfect. Amazing. Because banking companies are already regulated by RBI. So, in case if class action suit is filed against a banking company, it will create unnecessary panic among the investors of the banking company. For that reason, class action suit cannot be filed against the banking company. Right? Perfect, guy. Perfect, Rahul. Perfect. Now, let's come to the MCQ part. Yes, yes, yes. So, under section 244, what is the minimum number of shareholders required to apply to the tribunal in a company with share capital? What is the answer of this? Under section 244, what is the minimum number of shareholders required to apply to the tribunal in a company with a share capital? Whether 50 shareholders or 100 shareholders or 1/10 of total members, 200 members, or fourth is 100 shareholders or 1/5 of total members. What is the answer of this question? Answer is B. Veni is saying answer is B. Anybody else? Rahul Kanchan is saying answer is B. Sakshi Jaran is saying answer is B. All right, all right. Anybody else wants to answer? Anybody else wants to answer this question? Answer is B. Perfect. Swati Gupta, Sakshi, Rahul, Veni. Amazing, guys. Amazing. Swati Gupta, where are you from? Can you tell me, please? Next, what is the eligibility criteria for a shareholder in a company with a share capital to apply under section 244? Gopal sir, perfect. Gopal sir, perfect. At least 100 members, 1/10 of the issued capital. Number 3, 1/5 of total members. And number 4, both A and B. Yes. Guys, what is the answer of second question? Eligibility criteria for a shareholder in a company with share capital to apply under section 244. Rahul Kansara saying answer is D. Gopal sir saying answer is D. Sakshi is saying answer is D. All right. Anybody else? Wayne is also saying answer is D. Perfect, guys. Perfect. Perfect. Amazing. 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 Now, can the NCLT waive the eligibility requirements for filing an application under section 244? What is the answer of third one? Swati Gupta, answer is D. Perfect, Swati. Perfect. Yes, guys. What is the answer of third? Answer is Rahul Kanchan saying answer is A. All right. All right. Answer is A, guys. Very easy. Next. Yeah, this is interesting. Which of the following actions in the tribunal is the tribunal not authorized to take under section 242? Which of the following actions is the tribunal not authorized to take under section 242? Regulate future conduct of the company's affairs. Number 2, reverse fraud transactions. Number 3, issue an interim order during proceedings. And number 4, liquidate the company immediately. Yes, people. Yes, yes, yes. Rahul Kanchan is saying answer is D. All right. Anybody else? Which of the following actions the tribunal not authorized to take under section 242? Yes, Sakshi, Swati, Veni, Gopal sir, Pooja Gupta, Devika, Samarth Prasad, Atul PS. Where are you guys? Guys, come back, quick. Ganesh SP, where is Ganesh SP? Ganesh SP. Veni is saying answer is D. Okay. Guys, quickly answer me. Swati is saying answer is D. Guys, come on, answer. 16 people are watching right now and only 3 have answered. Guys, what is this? What is this? Guys, what is this? All right. So answer is, guys, perfect answer. Answer is D. Now next. Which of the following is a power of a tribunal under section 242? A. Removing the company's auditors, compelling members to purchase shares from others. Number 3. Changing the company's shareholders. Number 4. Imposing restrictions on dividend payments. Sakshi, Jallan, Gopal sir, perfect guys, perfect. Yes, what is the answer of fifth question, guys? Yes, people. Yes, yes, yes. Come on, quick, quick, quick. Guys, I would want you to make as many mistakes as possible, okay? Make as many mistakes as possible. This is the only platform where you can afford to make mistakes. In exams, you cannot afford to make mistakes, guys. Fifth answer is Rahul Kanchan is saying fifth answer is A. Okay, Rahul. Guys, remaining, everybody quickly answer me. Quickly answer me. That's absolutely okay if your answer is wrong. Rahul Kanchan is saying now answer is B. Okay, Rahul. All right, all right. The answer is B. You guys were right, right, right. People, let's take a break of 10 minutes, okay? Let's take a break of 10 minutes and then we will continue with the next chapter, that is compromise or arrangement. No, we will take dividend and investment and loans, okay? Somebody told me that investment and loans is a very, very boring chapter for them. So the first thing that we're going to take is investment and loans post this break. All right, 7:24. So we're going to meet at 7:34. All right, Sakshi Janan, perfect. Sakshi, perfect. You are right. Okay, let's meet at 7:34. Yes, people. Yes, yes, yes. Is my voice audible? Is my voice audible? Is my voice audible? All right, all right, all right. Come on, people. Quickly give me a thumbs up who are all watching this right now. Whoever is watching right now, give me a quick thumbs up, guys. Let's begin our next chapter, that is investment and loans. Investment and loans, guys. Yes, yes, yes. Everybody. Give me a quick thumbs up. Yes, yes, yes. All right. Atul PS is back. Everybody, give me a quick thumbs up. People. Are you guys with me? Sakshi Jalan is also back. Perfect, guys. Perfect. Swati Gupta, Gopal sir. Yes. Rahul Kanchan. Swati Gupta. All right. Swati Gupta, you did not tell me where are you from. Rahul Kanchan. Veni. Pooja Gupta. Everybody. Come back. Quick. Devika. Samarth S. Prasad. All right, guys. Perfect. Let's begin the next chapter, that is loan and investment by company. Swati Gupta is from Bilal, Chhattisgarh. Amazing, guys. Amazing. Perfect. Swati Gupta, I am from Pune. Okay. All right. Let's begin the next chapter, that is loan and investment by company. Perfect. All right. People, the basic rule says that company cannot have more than how many layers of investment? 2 layers of investment. A company cannot have more than 2 layers of investment. But exceptions. What are the exceptions? If company acquires a foreign company which has already got more than 2 layers of investment, then that is allowed. Next is, if company is required to have a subsidiary by law requires a company to have a subsidiary. Let's take an example of, I am from Pune, I have a company in Pune. I have to set up a company in SEZ zone. So that I can get tax benefit. For that purpose, I acquire a company in a SEZ zone. For that purpose, if I am required by law, then I am also allowed. Perfect. Then next, over here, what are the limits? Maximum amount of loan, guarantee, investment. What is the limit? 100% of paid up share capital. 60% of paid up share capital, free reserves and securities premium is the first limit, or 100% of free reserves plus securities premium, whichever is higher. So maximum a company can give loan, investment, guarantee up to a maximum of 60% of paid up share capital, free reserves and securities premium, or 100% of free reserves and securities premium, whichever is higher, is the maximum amount of limit a company can give loan, investment or make guarantee. Next, if at all company wants to give loan, investment, guarantee more than the limit, they can do, but provided they have to obtain special resolution. Now this special resolution is not applicable where? If it's a wholly owned subsidiary company, or the investment is made in joint venture, or the company is acquired by a holding company. In that case, special resolution is not required. Now what are the disclosures required to be maintained? Disclose in new financials plus full details plus purpose for which you have given a loan, guarantee investment to that company. You have to disclose the purpose along with all the details in the company's financial statement. Perfect. Now, can any decision be taken without a board meeting? No. If it's a very, very small decision, it can be taken without a board meeting. But it's a big decision. For that case, board meeting is required. Next, prior PFI approval is required if term loans exist and limit has been exceeded. Can anyone tell me what could be the possible reason for why this provision has been made? Prior approval of PFI is required if the company has got term loans. Can anyone tell me what could be the possible reason for a company to get approval from whom? Public financial institution, if the term loan already exists in the company. Swati Gupta, Rahul, Gopal sir, Sakshi, Atul, everybody quickly answer me. What could be the possible reason as per your knowledge, as per your opinion? Can you tell me what could be the possible reason for why a company has to get approval from public financial institution if already term loan exists in the company? Yes, people. Yes. Quickly tell me. Quickly, guys, tell me. सर हिंदी में होगा क्या मैराथन? एनी चांस? प्लीज रिप्लाई. वर्षिल कुराडिया, वर्षिल हिंदी में होना पॉसिबल नहीं है ब्रो, because I will tell you the reason why. Because we are going to write answers in English language, Varshil. But if I teach you in Hindi language, you will not be able to write answers properly, Varshil. That is a problem. Varshil, tell me, is my English too complicated, Varshil? I am using a very, very easy to understand language, Varshil. You can ask me doubts in Hindi, you can ask me doubt in any language that you can speak. I will try to answer your doubt in English language only, or also Hindi language. Credit worthiness check. Okay, Rahul, perfect. Yes, Rahul is absolutely right, guys. If a company has already got term loans and then it is trying to acquire more loans, then PFI's approval is required. PFI will check the company's financials, whether the company is really able to pay off all the loans or not. Credit worthiness will be checked by public financial institution. Perfect. Now, people, this board resolution requirement is not required when it's within the limits. Okay, that is obvious. But if it's a IFSC company, can anyone tell me why IFSC companies are not required to compulsorily pass a board resolution for obtaining or to make investment, to give guarantee or to give loans? What could be the possible reason for this provision? IFSC. Can anyone tell me the meaning of IFSC company? IFSC company is a company that deals with completely foreign clients. So Gujarat Gift City is a IFSC, right? So IFSC, just because it deals with so many foreign clients, it has to deal with a lot of time zones. It has to cater to all the clients having different time zones. So it is not possible to conduct a board meeting. We need to make decisions very, very quick, because we are dealing with people who have got different time zones, being foreign clients. Hence, for that reason, companies that has given lenience to whom? IFSC company, so that you don't have to conduct board meeting again and again. So that's absolutely okay, because you have got foreign clients. So we know that it is not feasible for board of directors to gather every time to pass a decision. For that case, in that case, board resolution can be obtained via circulation. Is everybody with me? Everybody understanding my logic? Everybody understanding my logic? Give me a quick, sweet thumbs up. Yes, people. Yes. Give me a quick thumbs up. Rahul Kanchan, Varshil Koradia, Swati Gupta, Veni, Gopal sir, Sakshi Jalan, Atul PS. Give me a quick thumbs up. Veni, amazing, amazing, amazing. Guys, when you give me a thumbs up, my energy becomes double. Okay. Yes, yes, yes. All right, all right, all right. Perfect. Now, SEBI regulated entities like mutual funds, merchant banks, or any bank SEBI regulated entities like, let's say, credit rating agency, mutual funds. These people are restricted from what? Intercorporate loans and deposits beyond prescribed limits. So first timer can watch this marathon. Mahesh Shah, first timer marathon can watch. Yes, absolutely. If you're able to understand everything, that means you can watch. No problem, Mahesh. In this marathon, all the important topics are covered, Mahesh. All the important topics are covered. I've also included all the expected questions that will be asked in exam. Along with that, I've given 50 MCQs per sub chapter so that your preparation is complete. Your preparation is 100%. So Mahesh sir, my answer is, if you are able to understand what I am saying in the lecture, if you are able to grab, then easily you can attend this marathon, Mahesh. All right. Now, people, SEBI regulated entities are restricted from what? Intercorporate loans and deposits beyond prescribed limits, because the reason is, even after special resolution, they cannot obtain loans beyond the limits. Because why? Because public's money is involved, public sentiments are involved. These are very, very sensitive entities. If something wrong happens with them, immediately panic will be created among the public. For that reason, these people cannot obtain loans beyond their prescribed limits. Now, if you are giving a loan to a company, what should be the maximum interest rate and what should be the minimum interest rate? Minimum interest rate should not be less than the government security yield of similar tenor. Government companies may lend at lower rates for specific purpose. For government companies, everything is allowed. But for non-government companies, you cannot give loans for a rate less than the government security yield. Next, default restrictions. No loan investment guarantee allowed if company has already defaulted in loan and deposit repayment. If you have made default in loan or deposit repayment, you cannot obtain more. You cannot give loan investment guarantee. Next, we'll talk about exemptions. Banks, insurance companies, housing finance companies, NBFCs, infrastructure finance companies are not covered in this rule. Whatever rules we have studied right now is not applicable to whom? Banks, insurance companies, housing finance, NBFC, infrastructure finance company, because these people are already have got regulator. For that purpose, it is not required. Plus people, plus, their ordinary business is into dealing in loans, investment, and providing guarantees. So for that reason, they enjoy exemption from the provision. Now we're going to understand some basic provisions. Company has to maintain registers of all loans, government securities, investments. Number 2, register must be at registered office open to members for inspection or copy. Next is, central government may prescribe rules for this section. Penalty is 25k to 5 lakh rupees. Okay. All right. Definition of investment company means what? Investment company whose assets, 50% of more of assets is in investment infrastructure facilities as per schedule 6. All right. Now we're going to understand deposit section. Everybody with me? Give me a quick thumbs up. Mahesh Shah, where are you from? Give me a quick, sweet thumbs up if everybody is with me. Yes, 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 people. Yes, people. Yes. Swati Gupta is there. Sakshiran is there. Okay. Great, guys. Great. Just give me a second, guys. Vaini is also there. Gopal sir also there. Perfect, guys. Perfect. Just 1 second. All right. All right. All right. All right. Now, let's begin the next topic, that is deposits. 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 So basically, the rule says a company cannot accept deposits or renew deposits from whom? Public, unless they comply with what? Chapter 5 and deposit rules. You cannot take deposits provided you cannot take deposits, you cannot accept, you cannot renew deposits. But if at all you want to accept, you have to comply with what? Schedule 5 and deposit rules. Chapter 5 and deposit rules. Now, exemption. Banking companies, NBFCs, other companies notified by central government in consultation with RBI, because their ordinary business is itself dealing with deposits. Their ordinary business is itself accepting deposits. So that's the reason why deposit rules will not apply to these category of people. Now, if at all you want to accept deposit from whom? From members, you will require a ordinary resolution. You will require a ordinary resolution. Number 2, you have to give a circular to all the members where you have given details as to financial information, deposit information, credit rating, and 4 is other details. People, I would want you to take a quick screenshot. When you take my print of the notes, you have to write all these things that I have written for you. All right, guys, everybody with me, give me a quick thumbs up. I would want you to take a quick screenshot of this notes right now, so that tomorrow when you print the notes for learning, for revision purpose, you should write all the terms that I have written in the notes. Yes. Next, you have to file the circular with whom? With ROC at least 30 days before issuance of the circular. Before you issue circular to any member, you have to first file this with ROC. Next, people are going to understand this after this topic, okay? No default certificate. You have to give it to the members. What? That you have not defaulted in any loans and advances. And last is, you have to provide a security as mentioned. If the security is unsecured, you have to mention that it is unsecured. If the security is secured with the assets, you have to mention that it is a secured asset. But you have to ensure that the security, there is some security for the deposits that you are accepting from the public. All right. Now comes the important thing. You have to deposit 20% of maturing deposits in a deposit repayment reserve account by 30th April. You have to deposit 20% of maturing deposits in deposit repayment reserve account by what date? By 30th April. Now, what does this mean, people? Imagine today's date is 1st April 2025. You know that in this year, 1 lakh rupees worth of deposits is going to be matured this year. So, you have to transfer this 1 lakh rupees where? To a deposit repayment reserve account. By what date? By 30th April, you have to transfer this into a scheduled bank account with a separate bank account named deposit repayment reserve account. This 1 lakh rupees you have to transfer. Easy. Is everybody with me? Is everybody with me? This is the condition number 1. Now, condition number 2 says that at least 15% of deposits maturing in value. Over there, what was the limit? Over there, the limit was 20%. But over here, it is 15% of deposit maturing value in a separate bank account by what date? Same date, 30th April, only for repayment purpose. Now, why these two conditions? Are these two conditions same or are these two conditions different? People, these are two different conditions but solving the same purpose. These are two different conditions but solving the same purpose. Let's understand with an example. Let's take today's date as 1st April 2025. Company has accepted deposits worth 10 crore rupees. Company has accepted deposits worth 10 crore rupees. But among these 10 crores, 4 crores worth of deposit is going to be matured next year. 4 crores worth of deposit going to mature next year. Next year means 2025 to 2026. Today's date is 1st April 2025. Next year, 4 crores worth of deposits from 10 crores is going to mature next year. Now, you have to do two things. Number one, 20% that we understood, deposit repayment reserve. 20% of 4 crores, that is 80 lakhs, you have to deposit in a scheduled bank account with a separate bank account named deposit repayment reserve. By what date? By 30th April 2025. This is the first condition that we understood. Second condition says that 15% of 4 crores, that is 60 lakhs, should be held in liquid assets. What does liquid asset means? Liquid asset means cash, government securities, etc. And 15% of 4 crores should be maintained in continuity. Should be maintained in continuity, so that anytime if deposit repayment, if deposit have to be paid immediately, you will have liquid assets to repay that. Understood, guys? This 30th April, the date is mentioned because 30th April is a date where compliance is checked every year, whether the company is maintaining deposits, whether the company is maintaining deposits that are maturing in liquid asset or not. Is everybody with me? Quickly give me thumbs up if you understood these two conditions. Normally students have got confusions in these two things. Everybody with me? Give me a quick thumbs up. Give me a quick thumbs up. Atul, Veni, Gopal sir, Swati, Sakshi, Mahesh, Atul PS. Give me a quick thumbs up. Give me a quick thumbs up. People, I would want you to take a screenshot of this also. Take a screenshot of this also. Sakshi, perfect. Everybody, give me a quick thumbs up. Give me a quick thumbs up. Okay. I want you guys to take a screenshot. Okay. I want you guys to take a quick screenshot. Is everybody hungry right now? Are you guys hungry? Are you guys hungry? Are you hungry, guys? All right. People, drop me the reply. Till then, I'm going to start the next topic. When I read the reply, I will reply to you. All right. Perfect. Now, no deposits can be repayable on demand. What is the meaning of repayable on demand? Tomorrow, if depositors demand immediately demand payment, the company cannot accept deposits that are supposed to be paid when the person demands. No. Deposits cannot be accepted for immediate payment. Okay. Next, deposits cannot be accepted for a period more than 36 months and a period less than 6 months. Deposits cannot be accepted by a company more than 36 months plus also less than 6 months. All right. Exception. If 10% of paid share capital plus free reserves, maximum limit is 35% of paid share capital free reserves securities premium. Which means what? A company can accept deposits, maximum, what is the limit? 35% of free reserves plus securities premium plus paid up share capital. Now, a company can also accept deposits that are more than 36 months but less than 6 months, provided the total amount of deposits is less than paid up share capital plus free reserves. All right, next. People, this is basic rule, okay? Now we will understand how much money can a company receive from members, how much money can it accept from the public. All right? Yes. Now, who can accept public deposits? Which company can accept public deposits? Which company can accept public deposits? Number one is companies with a net worth of more than 100 CR or turnover of at least 500 CR can accept public deposits. Only public companies can accept deposits from the public which has a net worth of at least 100 CR or turnover of at least 500 CR. Special resolution is required if you are going to accept deposits from the public. And number 3, you must have a credit rating. And number 4, charge on assets should be created within 30 days if secured. If it is not secured, I told you, you have to accept deposits from the word unsecured deposits. All right. Perfect, guys. Now, what are the deposit limits for members? For members, it is 10% of paid up share capital plus free reserves plus securities premium. People, in your module, it is given wrong. In the module says that 10% of paid up share capital plus free reserve plus securities premium is not there. Securities premium word is not there in your module. The right answer is a company can accept members maximum how much? 10% of paid up share capital, free reserves and securities premium. But from public, how much can it accept? Maximum 25% of paid up share capital plus free reserves plus securities premium. All right, for government companies, at least maximum company can accept 35% of paid up share capital, free reserves and securities premium. Now, interest and brokerage can't exceed RBI limits for NBFCs. Yes, we know this. Now, next is no retrospective alteration. No retrospective alteration. What does retrospective alteration means, people? Can anyone tell me the meaning of retrospective alteration? Can anyone tell me the meaning of retrospective alteration? Yes, people, what is the meaning of retrospective alteration? People, retrospective alteration means today I am accepting deposits, promising that I will pay 8% interest to the depositors. After 6 months, I cannot change the interest rate, saying that from now onwards I will pay 6% interest rate. That is not allowed. No change is allowed in deposit terms, trust deed or insurance after issuing circular. Correct, people? Next, deposit insurance is mandatory for deposit taking companies. Deposit insurance is mandatory. Now, let's take an example that I have taken a 10 crore worth of deposit. Now, for 5 crores, I will take insurance. For remaining 5 crores, I can create a charge on asset. Tomorrow, in case if I am unable to pay 5 crores deposits, now insurance company will pay them. For that, I am already paying them premium. But over here, and again, if I am unable to pay 5 crores, then charge assets can be sold off to repay the deposit amount. Easy. All right. Next, creation of security. asset must be created on unsecured portion. On whose favor? In favor of the trustee for depositors. Now, appointment of trustee. Company has to appoint a trustee before it issues any ad. Now, for that they have to execute what? Trust deed. Trust deed is a deed which is a proper agreement between the company and the trustee as to what are the responsibilities, what are the duties of the trustee and the company. Now, who cannot become a trustee? Directors, KMP, employees of company, or any person who is associated with the company directly or indirectly cannot become a trustee. Now, what are the duties of trustee? He should ensure that asset is covered properly. It should not be a case where I am taking a deposit of 10 crores, but I am only keeping assets worth of 5 crores as charge. Not allowed. Next, avoiding misleading circulars, which means what? Company is intending to pay 8%, but circular says that company is going to pay them 10 to 15%. Preventing breach of trust deed, which means what? Whatever roles and responsibilities company has promised in a trust deed, trustee is responsible for ensuring that the company is complying with the responsibilities mentioned in the trust deed. Next, calling depositors meeting if required. The trustee can call the meeting of depositors if he requires. And last is enforcing security, which means what, people? We know that company has kept assets as charged, which means what? In case of default, these assets can be sold off to pay the deposit. Now, who will enforce this? Trustee will enforce this. Protecting and resolving depositors' grievances. Whatever problems are faced by depositors, all those problems should be solved by whom? The trustee. Next, now trustee must call meeting if, which means what? Now we understood trustee has the power to call the meeting of depositors. Now, can depositors themselves call the meeting? Yes. When? If 10% of depositors by value agree. Any event that affects depositors' interest, which means what? Company has done any fraud, company has spent all the money that it has got, all the cash reserve it has got to acquire a company, right? In that case, trustee will call the depositors or depositor will themselves call the meeting, provided 10% of depositors by value agree to this. Now, filing deposit. Now that company has accepted deposits, what is the reporting requirements? Company has to file pending deposit details within 3 months of every financial year end, repay within 3 years or agreed term, whichever is earlier, which means what? Maximum maximum 3 years you can take, or agreed term, whichever is earlier. Liquid asset is done. Next is register of deposit. Very easy. Maintaining register at registered office, entering details within 7 days receipt, preserving for 8 years. Fraud, if intent is defraud is proven, officer is responsible. Penalty is 1 crore or 2x the deposit, whichever is lower, or maximum 10 crores. Officer can be jailed. Deposit is a very serious offense. It's a very serious offense, people. Now, is everybody with me? Give me a quick thumbs up. Is everybody with me? Yes, guys. Yes, yes. Atul, Gopal sir, Veni, Sakshi Jalan, Swati Gupta, Mahesh Shah. Everybody with me, give me a quick thumbs up. Give me a quick thumbs up. All right, people. All right. All right. Last topic of investment and loan. Then we will be talking about dividends. Dividends. All right. All right. Veni, Atul, PS. Perfect, guys. Perfect. All right, Gopal sir. All right. Guys, did you get the notes? First, tell me that. Did you get the notes? Did you guys get the notes? Give me a quick answer. Guys. Gopal sir, one sec. Vinny, why not? Definitely will get. 1 second. Yes, guys, I've told my team. People tell me day 1, day 2, day 3 notes. Did you receive or not? Rahul Kanchan, not complete notes. Why, Rahul? I will just talk to the team, okay? Did you receive this notes that we are talking about or not? Tell me quickly, did you receive these notes that you are learning from or not? Forget about handwritten notes, people. Handwritten notes, I wrote it this morning. So it is not possible to get you handwritten notes, people. Only day 3 notes in WhatsApp. Rahul. Okay. Till day 3 you got. Amazing. Perfect. Rahul Kanchan, just drop a comment below this YouTube video saying that give me notes. Okay. The team have your number, team has your number, so they will share you the notes on WhatsApp. Rahul Kanchan, not complete notes. Nope. Alright, guys, we'll talk about the notes by the end of this marathon. Okay, I will ensure that every single one of you has my notes. Okay. Perfect. Now, what are the types of debentures? People, this question can be asked for 7 marks straight. Explain the types of debentures. Very easy. Tenure based type. Redeemable means debentures are repayable. Next is irredeemable means debentures are repayable when the company is being liquidated. In that case only debentures will be repayable. Next, convertible based. The debentures are convertible into equity shares. It is called as convertible debentures. If the debentures are non-convertible, then it means debentures are not convertible. Very easy. Degree of conversion. Fully convertible debentures can be completely convertible into equity shares. 10 crore debenture can be converted into 10 crores worth of equity shares. For partly convertible debenture means what? Among these 10 crore debentures, only 5 crores are convertible, 5 crores are non-convertible. Optionally means people what? They will have the option to either convert or not. Secured means what? It is secured by charge. Unsecured means it is naked debentures, not secured by charge. Interest rate based fixed rate debenture means you will receive fixed rate of interest, and floating rate debentures means what? Interest will keep on changing. Coupon based Zero coupon means what? Debentures are taken at a discount and then they are repayable at face value. Is called as coupon based debentures. With this, we're going to understand one more important topic, people. One more important topic. One second. One more very, very important topic is remaining. That is loan to directors. Loan to directors, which says that a company cannot directly or indirectly advance any loans, including book debt. Book debt means what? Company is supposed to pay to a person, and then director on behalf of the company says that it's okay. People, okay, one second. A person is supposed to pay to the company for providing provision of goods and services, and the director on behalf of the company tells the person that no problem, you can pay me, you can pay to company after 1 year or 2 years. That is called as including book, that is called as book debt. So a company cannot directly or indirectly advance any loans, provide guarantees or offer security in connection with the loan taken by whom? Taken by whom? Taken by director of the company, Flipkart, or its holding company Walmart, or the partner or any person who is related to director. A firm in which director is a relative or partner cannot take loans from the company. Now, loans to a person in whom director is interested, which means what? I am a director in a company and my company is going to give a loan to my brother. So in that case, it can be provided, but at what conditions? Special resolution must be passed in a general meeting. Number 2, explanatory statement that I give to the shareholders when I give notice by calling of the meeting. That explanatory statement should mention what? Full details of the loans, guarantees, securities, purpose of utilization, for what purpose my company is giving my loan to my brother. And next is any other relevant facts, important facts has to be mentioned in the explanatory statement. Next, the loan must be used by the company. The loan must be used by my brother for not his personal purpose, but for the principal activity of that business only. Only for that purpose, my brother can use that loan. Next, definition of person in whom interested: private company where the director is a member or director. Number 2, body corporate where director holds or controls 25% of voting power. And number 3, body corporate whose board or MD or manager acts, means what? A company whose directors are accustomed to act as per my instruction. I am basically controlling the directors of the company. In that case, we are interested. In that case, we are interested. In that, next is exemptions. Loans are permitted in the following cases. Now, can I give loan to a whole-time director or managing director, people? People tell me, can I give loan to a MD or a whole-time director? Answer is yes, provided. If it is a part of employment conditions applicable to all employees, which means a company is giving loan to all the employees as a basis of employees' welfare. In that case, company can give loan to managing director. Number 2, if a part of a scheme approved by shareholders via special resolution. Okay, shareholders have passed a special resolution for a scheme that is for the employees' welfare. So in that case, MD or manager can be given a loan. Next, loans by loan providing companies, which means for companies whose ordinary business itself providing loans can lend money provided the interest rate is equal to government security yield. We understood this earlier also. Next is holding companies can lend to whom? Wholly owned subsidiary company, or provide guarantees or securities for such loans. Easy. Holding company can also provide guarantee or securities for what? For loans taken by the subsidiary company from a bank or financial institution, provided the loan is used for principal business activities. Which means what? Holding company can give loan to its wholly owned subsidiary, provided the wholly owned subsidiary company is using that loan for what? Principal business activity. We are done with this chapter. We are done with this chapter. Now, immediately, without wasting any time, let's now solve MCQs. People have also given you, okay, before MCQs, let's understand this. People tell me the answer of this. ABC Limited, a public company, has a paid up share capital of 50 crore, free reserves of 30 crore, and securities premium worth of 20 crore. The board approved a loan worth 80 crore to XYZ Private Limited, a subsidiary company. Shareholders raised concerns about compliance with the Companies Act 2013. You have to calculate the maximum, okay, you have to calculate the maximum permissible intercorporate loan amount under section 186. Number 2, explain the approvals required for the loan. And number 3, discuss the consequences if ABC Limited exceeds the limits. First of all, tell me, can this loan be given or not? Use a calculator and then quickly tell me, can loan be given or not? Yes or no? Shant KJ. Shant KJ, just drop a comment below this YouTube video. You will get your notes as soon as possible. Yes, people. Yes, yes, yes. I would want to solve this question and tell me, can a company give yes for principal business? Okay. Rahul, do you think this loan can be approved just by a board resolution or special resolution is required? Tell me. I've told you limits. 60% of paid share capital, free reserves and securities premium. If this exceeds, special resolution is required. Or 100% of general reserve or securities premium. If exceeds these limits, then special resolution is required. Now you tell me, Rahul, is special resolution required or just board resolution is all right? Swati Gupta, Veni, everybody, please answer me this question. Use a calculator, no problem. But quickly answer me the question. Quickly. 60 CR or 50 CR, whichever is higher. 60 CR. Okay. But the board has approved a loan on 80 CR, Rahul. Do you think the board can approve 80 CR loan? Yes. Perfect, perfect, perfect. SR is required. Calculation. So, we know that board resolution is required, obviously, but if it is exceeding 60 CR, shareholders approval is also required via special resolution. Very easy. Now, next question. PQR Limited granted a loan of 2 CR to Mr. A managing director, for his daughter's education. The company's articles of association do not restrict such loans. Shareholders allege this violates the Companies Act 2013. Analyze legality of the loan under section 185. Discuss exceptions that permit such loans. Explain penalties for non-compliance. First of all, tell me, can 2 crores loan be given to a managing director for its daughter's education? Answer in yes or no. If no, why not? If yes, why yes? Rahul, Shant, KJ, Swati Gupta, Veni, guys, please respond. Use a calculator, no problem. Gopal sir, please respond. Atul PS, respond. Sakshi Charan, respond. Mahesh Shah, Varshil Koradia. Guys, answer though. Give me the answer. Okay, no problem, guys. It's okay. People, we know that for personal purpose, loan cannot be given. Prohibits loan to directors without exceptions. Okay. Now, exception loan for ordinary course of business, it is allowed. Plus employee welfare scheme, it is allowed. Now, violation loan is for personal use, hence it is illegal. Hence, the company will be facing penalty and fine. All right. Now, let's move on to the MCQ part. In MCQ part only, you guys are super active. I know this. Yes. Tell me which of the following is an exception to the restriction on layered investments under section 186 subsection 1. If the company is a holding company, the subsidiary is required by law to have investment subsidiaries. If the company has a net worth of 100 CR, the company is a public company. What is the answer of this? Yes, people. Yes, yes, yes. Come on, come on. Quickly answer me the question. Guys, what's up? What's up? What's up? Why are you so low, guys? What happened? I hope everything is good, guys. Hey, guys. Hey, guys. Gopal sir saying answer is 2B. Okay. All right. So the answer is 2B, Gopal sir. You are right. Absolutely. Next. According to section 186 subsection 2, what is the maximum limit for loans, guarantees and investment that a company can make without a special resolution? His answer is A, B, C or D. Yes, people. Yes, yes, yes. Come on. Be quick. Be quick. Rahul, Swati, Shant, KJ, Veni. Answer is 3B. Perfect, sir. Perfect. Perfect. Rahul Kanchan, perfect. Atul, perfect. Amazing, guys. Amazing. Guys, where were you? Next. Which of the following transactions is exempt from requiring shareholder approval via special resolution under section 186? Perfect, Sakshi. Perfect, perfect, perfect. His answer is A, loan to directors. Answer is B, loan to a wholly owned subsidiary company. Number C, investment in foreign companies. Or number D, investment in listed companies. This is the last question, guys. Then we will talk. Then we will skip to the next chapter, that is dividends. Answer is 4B. Gopal's answer is 4B. Rahul Kanchan answer 4B. All right. Perfect, guys. Perfect, perfect, perfect. Yes, guys. Tell me the answer of this fifth question. If a company has outstanding term loans from a public financial institution, what approval is required before providing loans or guarantees under section 186, subsection 5? Yes, people. Yes, yes, yes. Come on. Be quick, be quick, be quick. Atul is saying answer is 5B. Gopal is saying answer is 5B. Rahul is saying 5B. All right. You guys are absolutely right. Sakshi is saying 5B. Amazing, Sakshi. Amazing. Now, guys, with this, let's begin our next chapter. That is dividends. Dividends, dividends. Very small chapter, people will quickly complete within 10 to 15 minutes max. All right. Then we'll talk about compromise arrangement amalgamation. That will be completed in half an hour. Then we will be done with this marathon. We will be done with the Companies Act 2013. For chapter 1.1, I will give you notes, people. By the end of this marathon, you will receive the notes plus MCQs. Okay. 1.1 chapter is super easy, guys. It is very easy. Completely, it is procedural aspect. If at all you require that my explanation is required for chapter 1.1, just kindly let me know. I will come up with a marathon for that chapter also. But people, I do not think so that you will need my explanation, because that chapter is super easy. But to make your work more easier, what I will do is I'll prepare notes exclusively for that chapter. Okay. All right. Is everybody with me? Give me a quick thumbs up. Yes, people. Yes. Gopal sir is giving thumbs up. Perfect, guys. Perfect. Now, let's talk about dividends. Dividend. Now, the first rules section is 123, subsection 1. Declaration and payment of dividend. A company can declare or pay dividend from three sources. Number one, from current year's profit, company can pay it. Number two, from undistributed previous year's profit, but provided depreciation has to be provided for both of them. And number three, combination of current year's profit and last previous year's profit. Very easy. Now, important point. Unrealized gains, notional gains, revaluation of assets, fair value changes must be excluded while computing what? While computing profit for gains. Which means what? These four items should be excluded while computing the total profit. Next, dividend cannot be paid from reserves except for one reserve only. What is that reserve, people? What is that reserve? Give me quickly answer. What is that reserve? That reserve is called as free reserves. Can dividend paid out of deposit repayment reserve or capital redemption reserve? Tell me, people. Can dividend be paid from deposit repayment reserve or capital repayment reserve? Capital redemption reserve. Quickly, guys, tell me quickly. Come on. Yes, people. Yes, 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 yes. So basically, company cannot pay dividends from any reserve except for one reserve only, and that reserve is called as free reserves. Now, before declaring dividend, any accumulated losses or unprovided depreciation must be set off first. Before declaring any dividend, undepreciated accumulated losses and depreciation has to be deducted first, and then remaining amount you can pay as dividend. If a company has defaulted in paying what? Public deposits, it cannot declare dividend. If you have defaulted in the public deposits, you cannot pay dividend. All right. Now exemption, government companies, we know government companies, all the exemptions in the world are given to government companies. Okay, next, declaration of dividend out of reserve. This is the heart. This is the heart of this chapter. Declaration of dividend out of reserve is the heart of the chapter, people. Now, first, let's understand what is the maximum rate of dividend that you can pay to your shareholders. What is the maximum rate of dividend you can pay to your shareholders? Maximum is, people, average rate of 3 preceding financial years dividend you can maximum pay as dividend, which means what? If in financial year 1 you have paid dividend at the rate of 10%, number 2 you have paid 12%, number 3 14%, then the average is 12%. You cannot pay dividend at a rate more than the 12%, number 1. Number 2, maximum amount that can be taken from the general reserve is 10% of paid share capital, free reserves and securities premium. You have to comply with all the 3 conditions. Not just complying one condition is enough. You have to comply with all the 3 conditions. So number 1 rule says that maximum rate of dividend can be average of the last 3 years rate of dividend. Number 2, now this condition is not applicable when the company has not paid any dividend in the last 3 years. Okay. Number 2 says that maximum amount you can take from general reserve is how much, people? How much? 10% of paid share capital, free reserves and securities premium. Now comes the important one, which you will always get confused. Now when you take money from the general reserve, maximum amount, forget it. But minimum amount, after you take money from the general reserve, after you withdraw money from the general reserve, the balance should be how much? 15% of paid up share capital. It is not 15% of paid up share capital plus free reserves and securities. No. It is only and only 15% of paid up share capital. So 3 conditions, 3 limits. Number 1, average 3 years rate of dividend, and number 2, how much? 10% of paid share capital, free reserves and securities premium, and number 3, when you take money from the general reserve, minimum amount should be how much? 15% of what? 15% of paid up share capital. That's it. You have to comply with all the 3 conditions. Now, after you have taken money from the 3 sources, first priority should be what? Setting of losses. First, you have to set off losses. Now, depositing of dividend amount. Dividend must be where? Deposited into a separate bank account within how many days? Within 5 days of declaration. So, once a company declares dividend, immediately within 5 days, it has to deposit in a scheduled bank account. Again, government companies, exemption, we know this. Now, interim dividend. Interim dividend means what? Dividend declared during the financial year or after the financial year, but before the annual general meeting. Let's take an example. So, this is a financial year. 1st April 2025 to 31st March 2026. If in between this financial year I am paying dividend, it is one type of payment, interim dividend. Number 2 is what? After financial year, that is 31st March 2026. After 31st March 2026, 30th September 2026, I have held the annual general meeting. So in between the annual general meeting and end of the close financial year, in between if I pay dividend, that dividend will also be considered as interim dividend. All right. Now, what are the sources of interim dividend? Number one is surplus in the profit and loss. Surplus in the profit and loss. Number two, current year's profit. And number three, profits up to the latest quarter. Number one, every company will have this reserves and surplus. Every company will have this reserves and surplus. So, from this surplus, profit and loss account can be used to pay source of interim dividend. And number two, current year's profit. And number three is profits up to the latest completed quarter, which means what? On, let's say, on 30th July, I have to pay interim dividend. Now, what is, which one is the latest completed quarter? 30th June is the latest completed quarter. So, the profit I have earned from 1st April 2025 to 30th June, I can pay as dividend. Easy, people, everybody? Everybody's with me? Give me a quick thumbs up. Give me a quick thumbs up. Everybody, give me a quick thumbs up. Hi, everyone. Atul PS, Sridharan, Gopal sir, Rahul Kanchan. Guys, are you with me? Those who are watching the video but are not responding, they can also give me a thumbs up. Perfect, guys. Perfect. People, it really means a lot for me when you are listening for me for so long, guys. Thank you so much. Usually people, what they do is they, after this marathon lecture is conducted, they watch this video on 1.5x, 2x speed. So people, you being with me right now really means the world to me. I will be very, very honest to you. Okay. Thank you so much, guys. Thank you so much. Pooja Gupta. All right. Next, if the company has made a loss till the last quarter, interim dividend cannot exceed the average rate of dividend in the last 3 years. That means what? Company has suffered a loss. Interim dividend cannot be more than the average rate of 3 years dividend. Now, what are other requirements? Interim dividend must also be deposited in a separate bank account within how many days? Within 5 days. It must be ratified in the AGM, which means what? Whatever decisions has been taken by the board, it should be approved by the shareholders at the AGM, annual general meeting. Now, payment of dividend, same process for both interim and final dividend. Once declared the AGM, dividend cannot be revoked. Today I am telling that I am going to give dividend. Tomorrow I cannot say that we are revoking the declaration of dividend. By mistakenly we told you. No, you cannot tell that. Now, mode of payment, check, warrant or electronic mode is allowed. Who can receive? Registered shareholder can receive, nominee can receive, banker can receive. Which means what? I am holding a bank account in the HDFC Bank. So I will ask HDFC Bank to receive dividend on behalf of me. Nominee means what? I have nominated my name to Atul PS. So he will receive dividend on behalf of me. And number first is I will receive the dividend. Bonus shares are different from payment of dividend. The meaning of this is, people, dividend means what? Any amount of profit the company shares with its shareholders is called as dividend. Now, what happens is company can convert the profits into shares and they can give these shares for free to shareholders, and that is called as bonus shares. So we are done with this chapter. Okay. If you once you are done with this people notes, then you can quickly read and revise from these mind maps. Okay. Again, table is there. Same content is same, but for quick revision before the exam, I have given you so that you don't end up wasting your even a single minute of time. All right. Now, let's solve MCQs. People, one more thing is there. Transfer to IEPF. Okay, guys, 1 second. Yes. All right. So chapter is not over, people. 3 topics is remaining more. So transfer to Investor Education Protection Fund. Which means what, people? If company Reliance has paid me dividend, now I have not claimed the dividend. Now what will Reliance do with that money that belongs to me? First of all, they have to transfer to where? Unpaid dividend account. Unclaimed dividend account kept for 7 years in unpaid dividend account. Next. People, 1 second. Do I have the mind map for this? Okay. Yes. First of all, I have to transfer to where? Unpaid dividend account. And that amount is kept for 7 years. Which means what? If in 7 years, nobody, if I did not come to Reliance saying that this dividend belonged to me, until 7 years, Reliance will keep this money. After 7 years, they will transfer this amount plus interest to where? IEPF fund. So Reliance will keep the money for 7 years. After 7 years, it will transfer to where? Investor Education Protection Fund. Now filing a form, they have to file form DIV5 with IEPF authority. Now keep records for 8 years. Name, all the details should be mentioned over here. Shareholder claims, entitled person can apply to IEPF authority for a refund of their amount. Very easy. So first thing, company has to transfer the amount to a unpaid or unclaimed dividend account. Then until 7 years, if I did not come to the company claiming for dividend, after 7 years, the company has to transfer this amount where? Investor Education Protection Fund. Now, failure to distribute dividend. If knowingly company fails to distribute dividend, imprisonment up to 2 years and fine up to 1,000 rupees per day during default. It's a very serious crime. Next, interest payable by company, 18% simple interest per annum on where? On unclaimed dividend amount. Exceptions is payment stopped by law, which means what? Court has told Reliance not to pay me dividend. Number 2, shareholder specific instruction cannot be fulfilled, which means what? I am telling Reliance that you have to pay me by hard cash dividend. I do not want to accept electronic mode. For that reason, Reliance has not paid me dividend. In that case, Reliance has got an exception. Number 3, dispute over right to receive dividend, which means what? There is a fight between me and my friend as to who is going to receive dividend, because we both are joint holders. So there is confusion in that. And number 4, dividend adjusted lawfully against dues, which means what? I have got some unpaid calls amount. So Reliance has told that your unpaid amount will be set off against dividend. And last is non-payment due to companies. Non-payment not due to company's fault. Which means what? Company has tried its best to pay the dividend, but due to some technical errors, due to some unforeseeable conditions, situations, I did not receive the dividend. In that case, I will not charge Reliance for non-payment of dividend. Next, how will the IEPF funds will be utilized? Refund of IEPF fund will be utilized for what? Unclaimed dividends, matured deposits, and matured debentures. Next, investor awareness for promoting investor education, investor awareness, and investor protection. IEPF funds is used by the central government. Next, disgorged amount of distribution, which means what? Because of some frauds, a lot of investors have suffered a loss. So for compensating for that loss, investor education protection fund is used. Next, legal expenses requirement, reimburse legal expenses for class action suit, which means what? Company has a class action suit was filed against the company has lost. Now company has lost. Now, who is going to pay for the class action suit expenses? From the Investor Education Protection Fund. Other activities, other investor protection activities as notified by law. All right. Now, last topic, then we are done, people. Okay. So, dividend distribution policy is mandatory for which companies? 1000 listed companies, top 1000 listed company based on market cap, voluntary for all companies. What must the policy cover? When dividends will or will not be declared, the policy should cover that. Company basically has to formulate a dividend distribution policy. Which company? 1000 top listed companies. What all details has to be mentioned in this policy? When will dividends be paid and when will the dividends be not paid? Number 2, financial factors based on which the company will pay dividend: profit, cash flow, EPS, liquidity. Internal and external factors, business plans, economic conditions, use of retained earnings. And number 5, treatment of different classes of shares. If a company drops out of 1000 listed companies for 3 consecutive years, then the policy compliance is not required. Everybody with me? Now let's quickly this is the once again this is the dividend distribution policy of Reliance. Circumstances under which the shareholder may or may not expect dividend. Just now we understood. Next, parameters to be considered before recommending dividend: profit earned during the financial year, retained earnings, earnings outlook for next 3 to 5 years, expected future or cash liquidity requirements. So all these should be mentioned in the Reliance dividend distribution policy, so that tomorrow if an investor is going to purchase shares of Reliance, he will know that when can he expect dividend, when can he not expect the dividend. Every single thing should be disclosed properly to the investor. So we are done with this chapter, people. Chapter done. Now people tell me quickly, MCQ part. A company that distributes a major portion of its profits as dividends is categorized as bad payout company, good payout company, reserve company, or fourth, retention company. Rahul Kanchan is saying answer is 3B. Okay, Rahul. Any other people? Yes, people, be quick, please. We need to complete this chapter as quickly as possible so we can start our last chapter, that is compromise arrangement. Yes. Yes, people, please be quick. The answer is B, Rahul. Perfect. Gopal sir, perfect. Now next. According to section 2, subsection 35 of the Companies Act 2013, the term dividend includes final dividend, interim dividend, both final and interim, neither final or. Rahul PS is saying answer is 3B. Vinny is saying answer 3B. Perfect guys, perfect. You guys are fantastic, guys. Fantastic. 4C. Perfect. No. One second. Over here, the answer is wrong, guys. Wrong. Answer is C. Rahul is perfect. Pooja is perfect. Gopal sir is perfect, guys. Perfect. Amazing. Now, I'm going to pick some of the difficult question, guys. Difficult question. Yes, this one looks little difficult. Yes, guys. Tell me what is the answer of this. Which People, next question, okay? Next question. While computing profits for dividend declaration, which of the following must be excluded? Realized gains, operating gains, notional gains, actual gains. Gopal sir is saying answer is 4C. Gopal sir, you are right. Atul, answer is not 4th B, Atul. Yes, people. Rahul Kanchan saying answer is 6C. Perfect, perfect, guys. Perfect, 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 perfect. Now, next. What is the time limit for depositing the declared dividend in a separate bank account of a scheduled bank? 3 days, 5 days, 7 days, or 10 days? Pooja Gupta, fantastic, fantastic, guys. Pooja Gupta is saying answer is 7B, 7B, 7B. All right, guys, fantastic. Yeah, this one is interesting. Board of directors can declare interim dividend only during the financial year, only after the closure of financial year, either during the financial year or at any time after closure until AGM, or D, only after AGM approval. Veni is saying answer 7B. Perfect, Veni, perfect. Nine C. Perfect, perfect, guys. Perfect. Amazing, 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 amazing. Rahul Kanchan, amazing, bro. Next, if a company has incurred losses in the current financial year, what is the limitation on declaring interim dividend? Number 1, cannot declare interim dividend. Number 2, cannot exceed 50% of previous year's dividend. Number 3, cannot exceed average dividend of preceding 3 financial year. Or number D, cannot exceed 75% of previous financial year's dividend. Ten C. Perfect, 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 Rahul. Perfect. Now, next question. What interest rate must a company pay for the default period of unpaid dividends? Perfect, Vinny, perfect. What interest rate must a company pay for the default period of unpaid dividend? மைதி மேடம் எங்க இருந்தது நீங்க ஏன் வரல? Pooja Gupta 13B. Answer is C, Pooja Gupta. It's 18% per annum. Perfect, Rahul. Perfect, perfect, perfect. Amazing, amazing, amazing. Now next. For how many years must unclaimed dividend be transferred to the after how many years unclaimed dividend must be transferred to the Investor Education and Protection Fund, IEPF? Rahul Kanchan is saying answer is 14C, 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 14C. Oh my God. Amazing, 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 amazing. Next, which of the following is not a source of funds for IEPF as per section 125 subsection 2? Grants from the central government, unclaimed dividends, income from company operations, proceeds from sale of fractional shares held for 7 or more years. Rahul Kanchan Singh answers 15C. Gopal Sir saying answer 15C. Veni is saying answer 15C. Income from company operations. Perfect, guys. Perfect. Yes. What is the answer of 19th? Amazing, Madhili. What is the maximum percentage of profit that can be withdrawn from free reserves for dividend declaration when a company has got inadequate profits? Nineteen C, 19C, 19C. Anybody else? Anybody else? Yes, yes, yes. Rahul is absolutely right. Guys, I told you, Maithili Pooja Gupta. Pooja Gupta, listen to me. I told you that you can withdraw the amount from the general reserve, but minimum you have to keep how much amount in the general reserve after you withdraw? Minimum you have to keep 15% of what? Paid up share capital you have to keep in the general reserve. You cannot take out of general reserve. Minimum you have to keep in general reserve. But how much can you take from general reserve? 10% of paid up share capital, free reserves and securities premium. Is everybody with me? Everybody with me? Everybody with me? Guys, over here we will make mistakes in the exam. Okay, I told you you can withdraw, but how much can you withdraw? 10% can you withdraw, but how much you have to keep minimum? 15% you have to keep. Very easy. Maithili confused आगा देंगो. All right, all right, all right. Next. Yes. Which of the following is not considered while formulating a DDP? Financial parameters, internal external factors, competitors dividend policy, or number 4, utilization of retained earnings. Perfect, Maithili, perfect. Yes, Rahul is absolutely right. (21C). Perfect. Yes. Which of the following, Gopal sir, perfect, Veni, perfect. Which of the following is not a type of dividend mentioned in the dividend policy framework? Interim dividend, final dividend, special dividend, preference dividend. Rahul Kanchan Singh answers 23C. Rahul, it is preference dividend. Okay. So tell me, people, tell me one thing. Have I ever spoke about preference dividend, or has your module ever spoke about preference dividend? So in dividend policy framework, there are basically three types of dividend: interim dividend, final dividend, and special dividend. Understood, guys? Yes, yes, yes. Atul P, yes, absolutely right. Absolutely right. Perfect, guys. Perfect. With this, let's take a break of 5 to 10 minutes. If you want, do you people tell me one thing? Do you want to have dinner? Do you want to have dinner right now? We can complete this chapter in next chapter in 20 to 30 minutes. Rahul Kanchan, special dividend is declared. 1 second. Special dividend, once you have declared a final dividend, immediately company has acquired a company, or a company has been acquired, or a company is financially progressing exponentially. In that case, company can choose to declare special dividend for the shareholders. Out of sudden profits, sudden exponential profit, if company wants to declare special dividend, they can give via special dividend. It is very, very rare, just a concept introduced in the module. Please continue, sir, please continue. All right, all right. All right, all right, all right, all right. Guys, what do you say? Rahul Kanchan, Gopal sir, Veni, Maithili, Solungo, do you want me to continue, or let's take a break of 5 to 10 minutes and then we will continue? I will require another half an hour max to complete the next chapter. So if you want to have dinner, people, you can have it. I will wait for you. Otherwise, we will continue. Whatever you say. Gopal sir, 5 minutes break. Perfect, perfect, perfect. Let's take a break of 5 minutes. Hey Siri. Guys, again I'm telling you, thank you so much for staying with me. Really. It really means the world to me, guys. I want to meet you guys. Really. I hope we create a group on WhatsApp. We guys, after this YouTube marathon ends, I'm going to really miss you guys. Really. All right. So let's take a break of 5 minutes. Hey Siri. 5 minutes timer.
5 minutes starting now.
Perfect, guys. Let's meet at 9:13. All right. Yes, people. Yes, yes, yes. Love your marathon with complete dedication and conception on it. Thank you, Pritam Saini. Thank you so much. Pritam Saini, are you watching? Have you been watching this marathon? Why didn't you ever reply to my messages? Pritam Saini. Pritam Saini, where are you from? Pritam Saini, where are you from? Hi guys, welcome back, welcome back, welcome back. Give me a quick thumbs up if you guys are with me. Give me a quick, sweet, cute thumbs up if you guys are with me. Pritam Saini, thank you so much for the kind words. Yes, Rahul is back. Rahul is back. Maithili, Vango Sikro. Veni, come back. Pooja Gupta is back. Gopal sir, come back. We're going to complete the last chapter. Atul PS, come back, bro. All right, all right, all right. Everybody with me? Let's begin our next chapter, that is compromise and arrangement. People. Can anyone tell me the meaning of compromise arrangement? I will tell you one example. People, we all know Tata Steel, based in India. Based in India. Tata Steel had acquired a company in UK called as Chorus Steel. Chorus Steel. Tata Steel had acquired a company called as Chorus Steel. The problem was due to demand supply issues, due to market trend issues, due to KCV Chandru. Hi KCV Chandru, where are you from? How are you? Due to some market changes, market fluctuations, Chorus Steel was suffering heavy losses. Heavy losses. Now, Tata Steel had only one option, to either sell the company or to close down the company, which would have resulted in 3,000 employees unemployment. Now, this is the situation. Sir, your good name. Pooja, my good name. You're are you asking my name after watching this marathon? My name is Balgopal Sridharan. Pooja Gupta. Yes, people. So, people, Tata Steel is based in India. Chorus Steel was bleeding losses. So, Tata Steel had only got two options, whether to close down the company or to sell this company. Now, there was another company which was also bleeding heavy losses in the steel industry. That was ThyssenKrupp. Have you guys heard the name ThyssenKrupp? From Tamil Nadu, Ninga. Okay, Chandru Gupta. I am from Pune, but my origin is from Chennai. Yes, Pooja Gupta, yes. So ThyssenKrupp was also a steel company in Germany, which was also bleeding heavy losses. Now, Tata Steel and ThyssenKrupp decide that instead of us bleeding losses individually, why don't we share the burden? Why don't we share the cost? Why don't we share the losses? So, because of this, Tata Steel has sold half of its portion to whom? ThyssenKrupp. It was a joint venture agreement. Where 50% will be owned by Tata Steel and 50% will be owned by ThyssenKrupp. So instead of bleeding individually heavily, both the companies decide to why don't we share our losses? Why don't we share our cost price? Now, why would ThyssenKrupp do this? Because ThyssenKrupp would get a lot of resources from this Chorus Steel. Material assets are there in Chorus Steel. So now, today, both the companies are super successful because of this arrangement. And this is called as compromise and arrangement. Now, how will this arrangement take place is what we are going to understand in this chapter. All right, everybody with me, give me a quick thumbs up. Give me a sweet, lovely, cute thumbs up. Everybody with me, everybody with me, everybody with me, everybody with me. All right, guys. KCV Chandru, Pooja Gupta, Vaini, Atul PS, Gopal sir, Rahul Ganchan, give me a quick thumbs up. Yes, 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 yes. All right. So, people, question will be asked in this manner. People, we will not read the question. You can read the question when you get the notes. Okay. Basically, any case study that is asked about the procedure for compromise or arrangement, any case study, your answer should be this. First of all, you will give, Tata Steel will give a application to National Company Law Tribunal saying that disclosing all the material facts, financial position, auditor's report, pending investigation if any, everything should be mentioned in the application to NCLT. If the Tata Steel is trying to reduce the capital, that should also be mentioned. Next, after NCLT approves, then Tata Steel will get the approval of consent of secured creditor. But we will study this afterwards. But right now, we'll only focus about first step, NCLT. Then, and in that application, it will include creditor's responsibility statement, protection measures, auditor's report, and valuation report. Creditor's responsibility statement will tell that how responsible are we towards the creditors, so that when we make any arrangement, no creditors should suffer a loss. So, once again, should suffer a loss because of us. Next is what protection measures are available to creditors in case if this deal goes wrong. Number 3, auditor's report confirming that we have got enough cash to be liquid. And number 4, valuation report by registered valuer. Very easy. Now, notice of the meeting. Notice can be, NCLT will order the company, NCLT will ask Tata Steel to either order a meeting of creditors or to either order a meeting of members. So if at all members are required, what all notice is required again? Send notice to creditors, members, debenture holders. Okay, that notice should include what? Compromise arrangement details, valuation report. And number 3, what impact it is going to cause on the creditors? What impact it is going to cause on the KMP? Are they getting any benefit because of this arrangement? Are directors or MD getting benefited because of this arrangement? Are promoters getting benefit because of this arrangement? And last is, if directors are interested in this arrangement, every single thing should be mentioned in the notice so that creditors will be assured that these people are not acting in their interest. These people are acting for the company's overall interest. Now that they have ordered a meeting of creditors or members, 75% of consent of whether it is members or secured creditors is required to proceed with this deal. First, NCLT's approval is required. Number 2, creditors or members approval is required. Now, after that, public disclosure, which means what? Uploading notice of the creditors, members meeting and documents on the company's website so that tomorrow, if any stakeholder is going to suffer a loss or it is going to harm his interest, he can go to NCLT saying that this deal is going to harm me. Number 2, listed companies must send this report to 2 people, SEBI and next is stock exchanges. Number 3, it also has to publish the notice in the newspaper. And the last is mention free document availability to anyone at the registered office, which means what? Anyone can go to registered office and check the documents with respect to arrangement. Yes, people, this is the procedural requirement basically. Now next, procedural aspect of the notice. People, this we will study from another context. One second. Is everybody with me? Give me a quick thumbs up. Okay, let's read it from over here only. Number one, notice should include what all things? Notice should include, first people will, notice should include how many things? 15 to 16 things. But how do we learn this 15 to 16 things? I have segregated similar items in one color. Disclosure of everything related to interest. Disclosure of interest of whom? KMP, directors, promoters, creditors, debenture holders and employees. Interest should be disclosed. Number one, no interest statement. If at all directors, KMP are not getting benefited with this arrangement, they have to give a declaration that we are not getting benefited. This arrangement is purely for the benefit of stakeholders. Number three, declaration of best interest. Statement affirming the scheme benefits stakeholders. Statement if scheme does not impact certain parties. Yes. So pink points are over. Pink points deal with interest. Now green points deal with disclosures. Disclosure of any pending investigation. Disclose any changes in the last 6 months. Next. Now approval or no objection. Details of approval or sanctions and documents for inspection. Latest audited financial statement, tribunal order, scheme copy, material contracts should be open for inspection. Next, regulatory approvals. Status of required regulatory approvals, which means what? Are you regulated by RBI? Are you regulated by IRDAI? Are you regulated by banking? Every single thing should be mentioned in the notice. Next, objection raised. Objection raised by members who holding 10% or 10% shares of creditors holding 5% debt, which means what? The creditors who hold debt worth of 5% on total value, if they have objection, or number two, members who are holding 10%, they have raised objection, they can raise an objection to this notice. Next, regulatory notice, sending notice to various authorities. This is procedure. Next, approval and sanction. If 3/4 of creditors or members agree, tribunal gives a thumbs up to this. Next, tribunal's order and scheme may include protection for creditors, dissenting shareholders or exit of, which means what? If a few shareholders are not happy with the scheme, a few shareholders will be the arrangement will not be in the best interest of the few shareholders. In that case, tribunal will ask the company to purchase the shares of these dissenting shareholder. Next, confirm meeting with accounting standards. Confirm that scheme complies with all the accounting standards. And number 6, filing or tribunal order within 30 days. People always understand. Absolutely love your teaching style. Thank you, VB. Where are you from, VB? So people, we need to understand one thing, that tribunal, whenever it orders something, always remember it has to be filed within 30 days with ROC. Okay. And next, exemption from creditors meeting. If 90% members, people, we understood that tribunal can ask the company to conduct the meeting of creditors or members to ask for their approval. Now, the meeting cannot be held when? If the creditors and members, how much? 90% of value. They are saying that we do not want to conduct the meeting. You can go ahead with the arrangement. So in that case, company is not required to conduct a meeting. Next, compromise includes takeover scheme. Compromise includes takeover. Scheme may include a takeover offer also. So which means, or compromise includes a takeover. All right. So people, I do not expect you to learn all these things, but at least learn the points. I have also helped you to bifurcate the similar points, green points, pink points, yellow points, blue points. Simply try to recollect everything and then write in the exam in your own words. Do not memorize or by heart any concept, okay? Do not do that. Otherwise, you will end up forgetting everything. Just try to remember. Just try to imagine scenarios. Easily you will be able to remember in the exam. All right. These are the procedural aspect of the notice we understood. Procedure for compromise arrangement we understood. Next. Now, what can be the possible orders National Company Law Tribunal can pass on the compromise or arrangement? Now that we have understood, company has to how the company has to approach the tribunal, how the company has to deal with the shareholders and creditors. Now, what possible orders can tribunal order on the company? We're going to understand. Now, tribunal supervises implementation. Means what? Ensures that company is complying with the scheme. Number 2, directions or modification. Tribunal may modify the scheme for proper implementation. Number 2, ordering winding up. If the scheme fails, the tribunal will order winding up. And last is monitoring reports. Tribunal may ask for periodic reports of the company from Tata Steel. Next is merger and amalgamation. Now that we understood arrangements, right? Arrangement means what? Tata Steel and ThyssenKrupp shared their losses by entering into an arrangement, right? This is called as arrangement. Now, what is amalgamation merger? We're going to understand. People, have you heard GSK company? Can anyone tell me that have you ever heard the company called GSK? GSK company. Quickly tell me, have you heard the company called GSK? GSK stands for GlaxoSmithKline. No one? Okay. People, Horlicks was owned by GSK. Boost was owned by GSK. And HUL, Hindustan Unilever, obviously you must have all heard that. Hindustan Unilever acquired GSK for a whopping 35,000 CR. I have uploaded a detailed video on this on YouTube. You can check it out for when I was explaining the takeover code, right? So this is called as, in this case, section 232 will be, we have to comply with. Company has to comply with section 2, the DSK and HUL. Yes, Rahul Kanchan. Perfect. Rahul Kanchan, have you watched my video, takeover code? All right. Rahul Kanchan, you answer me this question. Till then, I am explaining further. Now, in that case, what is the procedure company has to follow? Number 1, tribunal's power to order meetings. We know this. Sanction scheme for reconstruction, merger, amalgamation. Next, documents. What are documents for meeting? Draft scheme, director's report, expert valuation report. Draft scheme, director's report, expert valuation report. Okay. Tribunal's sanctioning order. We will understand this in detail, people. Just understand tribunal can sanction types of orders. Now, number 4, transfer of property and liabilities. Transferring property liabilities belong to transferee, which means what? HUL, GSK. HUL acquired GSK, so transferor is GSK and transferee is HUL. Sure, Rahul, sure. So, after HUL acquired GSK, that property of the transfer will belong to property of HUL. So, transferring property that belong to transferee company. Next, filing with the registrar. We know this within 30 days. And last is effective scheme and appointing date. People always remember, whenever a petition is filed for a merger amalgamation of scheme, whenever we send documents, financial statements, audit reports, director's report, we give these reports based on one date, and that date is called as appointed date. Not necessarily that appointed date and the effective date of the scheme should be same, but they can be same. Effective date means what? In the scheme, we are clearly telling to the NCT that we want this scheme to be effective from next year onwards. We want this scheme to be effective from 6 months from now onwards. This is called as effective date. Appointed date means what? The document that we are giving to the tribunal is based on one date. That is called as appointed date. All right, guys. All right. Perfect. Now, annual statement filing. File annual statement with ROC until scheme completion. That means what? Which means what? Until unless the scheme gets completed, which will take obviously 1 or 2 years to get the scheme completed. Till then, you have to file all the reports to the ROC. Understood, people? Everything? Everybody clear with me? Everybody is with me? Give me a quick thumbs up. Give me a quick thumbs up. Maximum 15 minutes, guys, then we will be done. Okay? Just give me 15 minutes, then we'll be done. People, I've given you case study question also. I've given you topic. Below that, I've given you case study question also, so that you don't end up just learning the topic and then when you see the case study question, you will get confused. No. So I've given you case study question also. First, you read the case study question, then you read the topic, so that you will be able to connect the case study question with the topic. Perfect, guys. Perfect, perfect, perfect. Yes, yes, yes. Amazing, amazing, amazing. So people, I will ensure that tomorrow everybody will get all the notes. Okay. Guys, tell me marathon day 1, marathon day 2, marathon day 3, marathon day 4. What all notes you did not receive? Immediately drop all your queries in the comment section. My team will give you the notes. Okay. My notes are very, 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 very important, guys. Do not ever skip this. Okay. All the important topics are there in the notes. All the expected questions are there in the notes. All the MCQs are there in the notes. So there is no reason that you should not read from the notes. There is no reason. If you read the notes, you can easily score an exemption. 70 to 80% syllabus is already completed in these notes, people. Okay. All right. With this, let's continue with the next topic. That is purchase of minority shareholders. DEF, a public listed company, is planning to buy out its minority shareholders under a scheme approved by NCLT. The company has agreed to provide an exit opportunity to the dissenting shareholders. Describe the process that DEF Limited must follow to buy out its minority shareholders. Now let's understand this. Yes. So, number 1, NCLT can force the company to buy out dissenting shareholders for smooth implementation of the scheme. Next, for that they give a exit opportunity. Okay. Valuation by share. Just because NCLT is asking the company to purchase a share of dissenting shareholder, and the company cannot purchase a share of dissenting shareholder by offering a very, very low amount. The amount should be done by a registered valuer, SEBI registered valuer, to ensure fair methods. Next, company must confirm minority shareholders' identity and shareholding after receiving funds, which means what? Now the company has arranged the funds for, let's say, merger, amalgamation, demerger, or arrangement. Now the company has arranged the funds. Within 2 weeks, the company has to confirm the minority shareholders' identity, so that shareholders do not come by fraud. They have to verify the identity. Next is company must declare in advance the record date for any corporate benefit, which means what? If I pay to the minority shareholders, after that I declare any dividend, I declare any bonus share, that means what? Minority shareholders have been done wrong, right? So they have to be informed in prior that we are going to do these corporate actions. So you plan whether to sell your shares or not. Otherwise, it will create confusion and dispute. Is everybody with me? Everybody with me? Give me a quick thumbs up. Next, now we are going to understand merger amalgamation of certain companies. What are those certain companies? People, now that we have understood a lengthy procedure for merger amalgamation, section 232, right? Section 230 deals with arrangement. Section 232 deals with what? Merger amalgamation. Section 233 also deals with merger amalgamation. Then what is the difference between section 232 and section 233? Section 232 deals with only for big companies. They have to follow a long procedure. But for certain companies who wish to complete the merger amalgamation in quick, fast-track manner, for them it is section 233. Now, who are the eligible companies who can do a fast-track merger amalgamation? 2 or more small companies, a holding company. People, listen to this very, very carefully. Holding company and its wholly owned subsidiary company. And number 3, any other class of companies. Okay. Now, central government has added holding companies, two or more startup companies, or one or more startup companies with one or more small companies. Now, exceptions. The simplified, the fast track procedure for section 230, the fast track procedure under section 233 is not available for whom? Holding and subsidiary company. Over here we understood holding and wholly owned subsidiary company. Over here it is wholly owned. It is only subsidiary company. Correct? There's a difference. Okay, people. Next, companies registered under section 8. And last is companies or body corporates governed under section 8. These people cannot merge or amalgamate through fast track merger amalgamation under section 233. All right. Now, let's talk about merger of small companies, holding and subsidiary company. Section 233 provides a simplified process for two or more small companies holding. Okay, this we are done. Now, what is the process? Process is almost the same, people. Notice and objection may be given to ROC, OL and affected person. Objection or suggestion must be submitted within how many days? Within 30 days. Company must issue a notice to the proposed scheme inviting objections or suggestions. Companies will give notice to everybody asking them whether do you have any objection, do you have any suggestions for this scheme. Next, approval of shareholders. Over here 90% of shareholders approval is required, but in arrangement we understood that 75% approval is required, but over here 90% is approval is required. Statement of solvency. Each company must file a declaration of solvency with ROC that we have got enough money, we have got enough plans, that we plan to continue with the company. We do not plan to close the company. We will be continuing with the operation of the company on a going concern basis. And next is approval by creditors. At least 90% of creditors must approve the scheme. A 21-day notice should be given to them before the meeting. All right. Documents accompanying the notice. The notice must include three things: a statement as section 230 subsection 3, which means this statement: disclosure of interest, investigation proceedings, shareholding pattern. Next is declaration of solvency, and then copy of scheme must be given. Now, what all possible orders tribunal can order on the scheme? Guys, everybody with me, give me a quick thumbs up. Give me a quick thumbs up who all are watching right now. Guys, everybody with me? Gopal sir, Pooja Gupta, Veni, Maidili, Rahul Kanchan. Is everybody with me, guys? Is everybody with me? Yes. Perfect, guys. Perfect. Sorry, guys, my voice is breaking. If at all you did not understand any word, just let me know. Sir, I did not understand this explanation part. This part, I will explain it to you again. All right, guys. All right. Perfect. Now, tribunal's order. Tribunal can order transfer of assets and liabilities from transfer to transferee company. Next, share allotment, issuance of shares or debentures to entitled persons. Next is ongoing legal proceeding, continuation of legal proceedings of GSK will be transferred to whom? HUL. Dissolution of GSA company without winding up. Number 4, dissenting shareholders. Provisions for dissenters. Next, non-resident shareholders. Allotment as per FDI norm, which means what? Shareholders are in foreign country. How will the shares be allotted to them? Employees transfer from GSK to whom? HUL. Listed transfer, unlisted transfer, which means what? Let's say HUL is a unlisted company and GSK is a listed company. Now that HUL is acquired GSK, unlisted company has acquired listed company. Now they have the option to be listed or unlisted. Next is fee set off of fees paid on authorized capital, which means what? GSK has already paid 10 lakhs for authorized share cap. Now HUL to increase the authorized share cap by 10 lakhs. By 10 lakhs. Is not again required to pay the amount that is already paid by GSK. Correct? Incidental matters, any other matters to complete the merger is done by, can be ordered by NCLT. A certificate from the auditor must confirm accounting compliance. Okay. Transfer of property liabilities, filing with the RO. Effective date, annual filing statement. With this, we are done with the chapter of compromise and arrangement, guys. Compromise and arrangement. Let's quickly solve MCQs, people. Uh-oh. Yes. Who among the following cannot apply to NCLT for a compromise or arrangement? Company itself, creditor, member, employee of the company. Who among the following cannot apply to the tribunal for a compromise or arrangement? A, B, C or D? Rahul Kanchan is saying answer is 6D. Yes. Perfect, guys. Yes. In a corporate debt restructuring scheme, what minimum percentage of secured creditors must consent? Pooja Gupta says 7C, 7C, 7C. Yes, guys. Perfect, perfect, perfect. Absolutely great. Yes. What majority is required for approval of compromise or arrangement? Last question, then we will end it, okay? People, I've given you 50 MCQs per sub-chapter. Please try to solve everything. I've also given you answers so that you don't have to spend time in searching for the answers. Everything is given in the marathon notes, okay? Everything. You don't have to look at anything else. Rahul Kanchan says 9D. 9D. Rahul Kanchan, are you sure? Are you sure? Are you sure, Rahul Kanchan? I told you, Rahul Kanchan, as per section 233, Vinny says 90, 90, 90. Answer 75. Guys, I told you, see guys, 90% consent is only required when it is merger amalgamation through section 233. Fast track merger amalgamation. Otherwise, 75, 75, 75 is required. Understood, guys? Understood, guys? You will get confused in the exam like this, okay? For section 232, except for section 233, all the consent will be required by 75%. Section 233, fast track merger, will require 90%. All right? Yes. Last question, then we will end it. When can the tribunal dispense with calling a creditors meeting? 75% agree with affidavit, 90% affidavit. If all creditors agree with affidavit, never. over here also you will try to make a mistake over here. B. Perfect, Rahul. Perfect. If consent is required from the shareholders or creditors to not to hold the meeting, 90% consent is required. That's it, guys. That's it. Guys, there are a lot of viewers watching right now. Who all are watching right now? Give me a thumbs up and tell me where are you from. So then we will end this lecture, people. Okay? Just let me know if you need anything else apart from this marathon. I'll be happy to give you everything that can help you score an exemption in corporate and economic laws. Your exam is like my exam, people. If you are stressed, I am also stressed. So whatever help is required from my side, I'll be happy to help you guys. All right. Welcome, Rahul. Welcome, Vinny. All right, people. So we will end our marathon lecture day 4 over here. We are completed with 60 mark syllabus. 60 mark syllabus is completed within just 4 days. Remaining tomorrow, we will try to complete insolvency bankruptcy code plus corporate governance, and then we'll target the small chapters. All right. Perfect, guys. Perfect. Thank you so much for your kind support. Welcome, Pooja Gupta. Welcome, Atul PS. All right, guys. Thank you so much for staying with me, listening to me for so long. Thank you so much, guys. This really means the world to me. I cannot explain how much this is, how much this means to me. All right, guys. All right. Perfect, guys. Perfect. So we'll end this lecture. Have your dinner, sleep well, take care of your emotional health, take care of your body, sleep well, eat well, drink well, and study well. I will see you tomorrow, day 5 of Corporate Economic Law Marathon Lecture. All right. Yes, people. Good night. Take care. Bye-bye. Bye, Gopal sir. Thank you so much for your effort. Gopal sir, welcome. Welcome, sir. Welcome. Welcome, Maidili. Bye, Atul. Bye-bye. I'll see you tomorrow, guys. Bye, Vinny. Bye-bye.